It's a little after 8 o'clock now, and we're supposed to start at 8. So I'll start with just introductions. Once again, I welcome all of you folks to PAMIC's Executive Board and Roundtable discussion. It's only a morning session today, and we have lots of great speakers and topics of interest. Our first speaker today is Jerry Theodoro. He's going to be talking more about insurance from a public policy perspective. Many of you folks probably know Jerry from his days at Conning. He was actually a speaker at one of our sessions a couple of years ago as well, when Conning had done a big study on the state of the mutual insurance industry. Jerry has now moved on from Conning and is the director for finance, insurance, and trade policy with R Street. Is it R Street Consultants or R Street Institute?
R Street Institute.
R Street Institutes, which is a big public policy think tank out of Washington, D.C. They've been around a long time, and now Jerry gets to focus on the industry that we've all chosen for our careers and that we love to work within. So Jerry was the director of insurance research at Conning in Hartford. In his 12 years at Conning, a leading insurance assessment manager, and Conning is a leading insurance asset management and research firm. Jerry was highly sought after. His insights and publications on a broad range of matters impacting property and casualty insurers, and was in strong demand as a keynote speaker at conferences. Prior to Conning, Jerry worked for the global insurance giant American International Group. It's a pretty big company, as we all know, in a variety of global underwriting operations and strategy roles, including close to a decade of expatriate management assignments in Europe and Middle East. So he's also very well traveled. He now calls Connecticut home. So he's back in the States now, enjoying life in the Northeast. Jerry holds a degree in political science and public policy from MIT and a bachelor's from Cornell University. So Jerry, I want to welcome you again, and thank you so much for being our kickoff and keynote speaker this morning for the Executive Board and Roundtable. So Jerry, I'm going to hand it off to you, and you have the next hour or so to impress our audience.
Thank you, Ron. You're setting the bar pretty high. Appreciate the invitation to be with you, and thank you, Brittany and Andrea, for all the logistics and setting me up, teeing me off. And good morning to all of you. It's a pleasure to be with you. As Ron said, we all love this industry that we work in, above and beyond the fact that the insurance industry keeps the economy humming with its trillions of dollars of investments in infrastructure, in bonds that power our corporations and keep our municipalities going, and provide products like clinical trials, without which we wouldn't have vaccines. Above and beyond that, it's the people of the industry, I think, that make it a great industry. After working for large companies, I started at Chubb, I was at AIG. I had the opportunity through PAMIC to discover the wonderful people in the mutual sector. I was at Nemacolin, as Ron mentioned a few years ago, where I met wonderful people. Some of my best memories of in-person conferences. Do you remember in-person conferences? Haven't had those for a while, but meeting companies and people at places like Goodville and Lidditz and Pennsylvania National, real wonderful people, formed some great relationships. So it's an honor and it's a pleasure to be back with you again, albeit remotely. And I do look forward to seeing you, some of you soon again, because I'm still in the industry, the property casualty subject matter expert within R Street, and bringing my thoughts and understanding of the industry to a different audience for a different platform. It's about public policy now. R Street is a right of center think tank that looks to improve public policy in my area in matters impacting property casualty insurance, reduce subsidies that provide the wrong incentives, and to watch out for regulations that can stifle the industry and keep the competitiveness going. So working on lots of areas. This morning, I'd just like to share with you some of the items on my research agenda. One of them is social inflation, what's happening in the world of tort trends on the liability side. Another one is risk-based rating. There's a battle brewing in many states with the ability for insurers to use data to come up with actuarially sound rates. Right to repair, something that's impacting insurers of personal automobile, private passenger automobile. And if we have time at the end, I'll touch on some of the work I'm doing on the to reform the National Insurance Flood Program and taking a look at what's happening at the Federal Insurance Office. And if you have questions, feel free to send them through the Q&A box, which is at the bottom of your screen on the bottom right. And those will go over to Ron. And Ron, you're welcome to interrupt me mid-sentence or at any time if you want to shoot a question or hold it to the end. Ron is moderator, so we can keep it a little bit interactive if possible. And at the end, I'll certainly leave time for questions then if you want to hold them to the end. So I'm going to start by talking about some of my observations on tort trends and social inflation. And I'm going to start with a story. Everybody loves to hear stories, and this is a true story. A couple of weeks ago, I discovered an app. There's an application that's out there, and this app is called Do Not Pay. So if you have a chance at some point, I invite you to Google and to go into donotpay.com. There's no spaces between do not pay, but donotpay.com. And what is donotpay.com? Well, it calls itself the world's first robot lawyer. And it describes itself further. The Do Not Pay app is the name of the world's first robot lawyer. And with it, you can fight corporations, beat bureaucracy. And here's the important one that captured my attention. You can sue anyone at the press of a button. So that really got my curiosity going. Sue anyone at the press of a button. Sue anyone. So within the app, there's a drop-down box on sue anyone in small claims court, and you're taken to 58 different kinds of lawsuits that you can bring to facilitate you bringing a lawsuit. So I did one just for the sake of doing a sample, suing a hospital for malpractice or negligence. So if you click on that, you swipe right to sue, and now, and I quote, now you can file lawsuits the same way you find hookups on Tinder. Didn't know what that was because I've been married to the same woman for the last 20 plus years. That's a dating site. Apparently millions of people have been hooked up on Tinder. So now this is as easy as doing that. And then there's lots of good information on medical malpractice insurance or medical professional liability. So evidently they did their work. And so you follow the steps, you log into Do Not Pay, you select the Sue Now product, and step by step, you're taken to doing a lawsuit. Now, prior to starting my career as an analyst about 12 or 13 years ago, as Ron mentioned, I worked in the industry. I worked at insurers, and I was a casualty underwriter. I did liability underwriting. And if you were to show me or tell me 20 years ago that there's something on my telephone that allows me to just sue anyone, I would have thought that was like an insurance-related skit on Saturday Night Live. But this is real. And this is saying something about the direction of tort trends, if you can just sue anyone at the click of a button. Another anecdote I'll tell you that is indicative of what's going on in the world of torts and impacting insurers is, well, in the last year with restrictions, working from home, I was watching the news a fair amount, cooking and cleaning, doing house chores, so listening to the news so I could keep my my mind going a little bit. And as we know, a lot of the news programs, the commercial news outlets have about 50% or 60% commercials versus actual reporting and analysis. And one of the commercials that kept coming up is mesothelioma.com. Call mesothelioma.com or log into it or call this number and you'll get a free book. And after hearing this commercial hundreds and hundreds of times, literally, I actually went in and said, okay, I want this free book. And instead of getting a free book, I got several emails with solicitations from local plaintiff attorney firms in the area here in Connecticut, mainly in New Haven, that are working as co-counsel with the big guns of the plaintiff bar, some of the big asbestos and mesothelioma litigation firms, and got the book and got some information eventually, and learned that there are firms out there that have specialized in this field. That's all we do. Mesothelioma, that's all we do. And that's a critical comment, and we'll get back to that and why it's important. So advertising and specialization in the plaintiff bar. Last anecdote I'll tell you, anecdote number 3, is last week I took my first business trip after being at home and not traveling for the last 14 months, and I was in Miami, Florida. And in Florida, there is a situation there which is out of control in the realm of homeowners insurance. Roof repairing firms, roof repairers are knocking on doors and giving out free steak dinners if the homeowner will allow them to look at their roof and find some sort of imperfection, and they will then take it over to an insurance company to have the entire roof replaced. It has become a racket. There was a bill that was passed just a couple of weeks ago to try to stem this trend. But what this tells us is that the liability situation, the tort trends, are not just affecting what we typically think of as impacted by rising liability exposures, commercial general liability, products liability, medical professional liability, excess casualty, but also homeowners because of the liability component of homeowners. And in the state of Florida, the situation is the following. Florida has got 8% of the homeowners claims in the entire country, which kind of makes sense because Florida's got about 6% of the population. So a little bit more disproportionately in terms of the number of homeowners claims because you've got the severe weather and all that in Florida. But at the same time that it has 8% of the claims, it has got 76% of homeowners litigation. So this is why I say that the situation is out of control. Citizens insurance is, instead of getting depopulated, is getting repopulated. Private market insurers are going to be pulling up their, pulling up and pulling out without even factoring in the increases from reinsurance rate increases. So there are some things that appear to be going on. Now, these are examples or manifestations of what the industry has been calling for the last couple of years, social inflation. So the question is this something new, or is it just an old phenomenon that's just manifesting itself in different ways? Well, it's new in some ways, and it's not new in others. Now, how is it not new? Well, the first time that the term social inflation was used in the context of insurance was in Warren Buffett's letter to shareholders of 1977. And in that letter, social inflation was defined by Buffett as a broadening by society and juries of what is covered by insurance policies. And if we go back to 1977, what was happening was that was a few years after the sea change in the world of liability, where the pleading standard went from negligence to strict liability, and we had a shift to bring suits to court from something being probable. Does this event probably involve the actions of a defendant, or is it plausible? Can you make the argument? And then it eventually shifted to, is it possible? So if it's possible, if the pleading standard is so low as it's possible, then you can bring anything to court. Whereas before, when you had a higher pleading standard, there would be a much higher chance of the suit not advancing, passing motion for summary judgment or for dismissal. So that opened up a torrent of litigation, which ended up in the liability crisis of 1986. At its peak in 1986, Time magazine had its famous cover, "America, your insurance has been canceled," as scouting troops and packs and summer camps and public swimming pools and obstetricians and other people that were targets for lawsuits found that the liability coverage was just so expensive or unavailable. And the solution came out of Bermuda with the formation of ACE and XL to provide excess casualty insurance and to introduce reforms. So it's been around for a long time. That was 1977, which led to the liability crisis of 1986. But after that, the term came back again just over 10 years ago. In a 2010 publication by Partner Re, the publication introduces the term social inflation and defines it as follows. It's the increase in insurance losses caused by such factors as higher jury awards, more liberal treatment of claims by work comp boards, legislated rises in compensation benefit levels, and new concepts of tort and negligence. It's of concern to reinsurers and insurers because it's hard to predict social inflation trends, making it challenging to underwrite and price risks such as work comp, D&O, med mal, and general liability and public liability, which are most vulnerable to this phenomenon. And I'm sure that this resonates with many of you. So you see, it's not new in that sense because we've seen this movie before. But although gray hairs in this industry doesn't hurt, there's a danger to thinking that there's nothing new under the sun, that we've been through this, that we had the under reserving just prior to 9/11 in 2000, 2001, which led to rate increases. We had the crisis of the 1980s. So to think that this is just another swing of the pendulum in a cyclical industry, rates are cyclical and liability and work comp has been cyclical. So this is cyclical as well, and it'll get better. If we think like that, then we close our eyes and we are blind to some of the factors which are different, which set this apart, which make us think about what is going on and what do we have to do about it, rather than just raise rates and get more discriminating on insurance. So I'd like to point out some of the things that we need to be aware of, to think about, to be sensitive to, which make this different and can call for a different kind of response. First of all, we've got attorney advertising that has exploded. I mentioned before how I was, sick and tired of hearing mesothelioma.com, and I finally, got my free book just to see what was going on there. The amount of attorney advertising, you see it on billboards on the highways, you see it on the internet as soon as you Google anything, you see it on the sides of buses, personal injury lawyers advertising all the time. And there is a firm that, because these are just anecdotes, that actually quantifies the amount of legal advertising. And that's an interesting thing to follow. It's called ex ante. Ex ante actually measures the amount of attorney advertising. And they found that in the last couple of years, there was a 77% increase in attorney advertising. And in the quiet button-down period of 2020, it also did not slow down. The only thing that slowed down was the advertising relating to suing for Roundup, the weed killer. But if you take out the Roundup factor and the decrease there because of the massive settlement, attorney advertising did not go down in 2020 as other things dialed down. So attorney advertising is really a major factor that gets to people the way it got to me with the mesothelioma.com. And another thing that's different is in the realm of politics. You would think that when you have a Republican administration, as we had with the two most recent Bush administrations, there would be more tort reform because Republicans are typically conservative and supportive of big business. But in the last 4 years, we had a Republican administration that was populist and did things that were antithetical, that were negative for big business, because the Republican Party shifted to the party of the working man. So stick it to the corporation. So this is a new phenomenon that goes against the traditional or the conventional expectations of conservative Republican administrations, pro-tort reform, and Democratic administrations, more plaintiff attorney oriented. So we had a break in that cycle as well. So there is something different. There is something new under the sun. Another phenomenon which is new, which we did not have in the last explosion of the cycle in 2000, 2001, and certainly in the 1980s, a new phenomenon that we need to be aware of is litigation funding. Firms that advance money to plaintiff attorneys, the lawsuits that they're trying to bring are larger, and sometimes a small plaintiff attorney firm doesn't have the $600,000 or $700,000 it takes to develop a commercial auto or trucking accident case. So litigation funders collect investments from third parties and invest in that litigation, invest in those suits. And when they win pretty big. If you want to learn more about this phenomenon, one of the largest litigation funding firm in the United States is called Burford, B-U-R-F-O-R-D. It's publicly traded, so there's a lot of disclosure there, annual reports, 10Ks, quarterly reports, and they describe the model, and it is a remarkably profitable model. The business for Burford has risen exponentially, and the margins are in the high 30s. It's really good business, and it is something that is stoking, it's financing plaintiff attorney litigation for the big ticket items, the ones that go big, like pharmaceutical products or some large truck accident cases that have led to what we call nuclear verdicts, which are awards that are $10 million or more. So litigation funding is a new phenomenon that we didn't have. Another one, which is partially related to that and is very important, and a lot of the industry is not even aware of it, as I talk to claims departments, is phantom damages. Phantom damages, and this is a situation where you have an injured third party, maybe slightly injured, is directed by an attorney to a medical provider that bills at 3 or 4 times higher than what is customary, or may perform unnecessary surgeries, also at an inflated price. So these third parties are generating these bills that go into the high 6 figures, and they're presented in court after the case is silent for a couple of years, and they come out of nowhere. And again, the medical spend is several times higher than the actual amount that's paid. See, it's the difference between what's billed and what's paid. Just like if you go to a hotel in Philadelphia or Boston, and the rack rate you see there behind the door, it says $675 a night, but when you check out, you're only paying $200. The difference there is the phantom damages, and a lot of plaintiff attorneys that have dominated in some states have made it impossible for jurors to see the amount that was actually paid. And I came across this phenomenon a couple of years ago in California, in commercial auto, and also heard about it. Some companies are suffering from it in New York State and in New Jersey and in Louisiana, where it's become a real racket, and even Indiana. So it's metastasized. And this phenomenon of phantom medical damages is a real important one. And it's one that's being fought in the realm of public policy. There's some model legislation that's been presented, but in many states, the plaintiff bar is very close to the state legislatures. So phantom billing is allowed in many states, and it is another factor which is new and is stoking this liability phenomenon that we have now. And we're seeing it in the numbers too. D&O premium was up 42% in the last year, all rate driven. Cyber up about 35%, also rate driven. So we're starting to see it in the numbers as courts open up again in 2020. We're probably going to see it in other areas and in other pockets as well. And probably the most important development, which is new, again, not something that we've seen before, not the same old movie, is some of the structural changes at the plaintiff bar. I mean, there's always been talented plaintiff attorneys. I mean, I think of Joe Jamail of Texas, and Milberg Weiss, Bill Larack, who dominated class action litigation and D&O in in the 1990s. But the trends that are being seen there now have shifted and are becoming more intimidating. The book that was released about 10 years ago, the reptile theory, is used by plaintiff attorneys to get juries to believe that the actions of the defendant are in some way a danger to society, and it's their role. It's the jury's responsibility to change things, to punish these greedy, unsafe defendants, and to change the industry, to make them into crusaders, to get them agitated and aggravated, and to have animus towards the defendant. The defendant is an anonymous company. It doesn't have a heart. It doesn't have a brain. And that was the part of the closing argument in this case a couple of years ago in Texas, a commercial accident case, where the plaintiff attorney had this powerful closing statement saying this corporation doesn't have a heart, doesn't have a brain like the rest of us, and we can't punish it in the traditional way. The only way we can punish it is in the pocketbook. And the jury was turned on by that argument and awarded $110 million for a case where the injured third party was not even a fatality, but he drove off after the accident. So this is something that we didn't see. The explosion in these large nuclear verdicts is a new phenomenon. If you talk to reinsurers, you'll hear about the number of these large cases that are on their desks that they didn't see before. And as I mentioned, with the litigation funding, typically the cases they are investing in are ones that go for $1 million or more. This is elephant hunting. And even though we don't have maybe the Joe Jamails of the past, what's happened in the plaintiff bars is a lot of specialization. Remember before I said mesothelioma.com? That's all we do. Which is different, because go back 10 or 20 years and your typical plaintiff attorney firm was an all-purpose firm that did med mal, did automobile, did products liability, did trucking, trips and falls, did all sorts of things. If you look at their literature, whereas now there's specialization, and there's also been a migration within the plaintiff bar, because the tort reforms that we had in the last two Bush administrations, the tort reforms really closed the door for a lot of the opportunity, medical professional liability, medical malpractice with caps on non-economic damages, made med mal less attractive, made it a less rich profit center. So some of the sharper attorneys that were in med mal gravitated to other areas where they could specialize, like commercial auto, where they could present the case of a severely injured third party and pull at the heartstrings of a jury. So you've got this migration into new areas of litigation, and also the specialization, which we didn't have before, and also related to specialization, sharing of information. Plaintiff bar is very well organized with conferences and working as co-counsel, whereas defense firms are typically less cooperative with each other. It's a different model. And these there have been some abuses. I mentioned Louisiana before, and in New York State also, in Brooklyn and Long Island, staged accidents which are criminal, have been driving up a lot of the commercial auto claims for some companies that have driven up rates, and have led some companies to throw in the towel, and risk retention groups. So those are some of the new ways in which the liability situation is not what it was. Maybe I'll pause at this point, and if there's any questions on the liability side before we talk about some of the other public policy areas, or any observations people would like to share. I'm going to check.
Jerry, this is Ron. We didn't get any. We didn't receive any questions specifically, but I find it fascinating. You know, the historical look at the liability market and its impact on insurance, and how what we thought of historically, we really can't use that set of guidelines anymore because of so many changes in the way our markets are working. So this just makes our life that much more complicated than ever before. So I find it, I just think your research is amazing, and I thank you for sharing this kind of information. As you know, you probably follow ATRA and their reviews of various jurisdictions, and Pennsylvania, more specifically Philadelphia, always seems to rise close, if not the #1 judicial hellhole. I think that's the term that they use. We're always very close to the top. Have you done any research at all at looking at what's happening in the Pennsylvania markets? And one of the reasons why this is important is, as our membership grows in terms of the kind of products it's offering to the consumer, a lot of them want to move into the commercial space. It's very, very competitive, but can be very lucrative at times as well. But these kind of lawsuits obviously temper that kind of financial situation. So that's my question. Have you taken a look at Pennsylvania specifically, and do you have any comments about what you're seeing here?
Yeah, thanks. I'll answer the question first, and then go back to your comment. I did have a peek at what was going on in the Pennsylvania Trial Lawyers Association, or whatever it's called, Pennsylvania Association for Justice.
For
the
justice.
Organization. I'm sorry.
Yeah, for justice. Yes.
Right. Yeah. Justice. Yeah. Just like you started this presentation today, before you saw my face, you saw the sponsors of PAMIC. So the first sponsor of the Pennsylvania Association for Justice that's posted up there, so it's probably the largest sponsor, is what? It's a litigation funding firm. So I forgot the name of it. It's not Burford, could be a local one, but yeah. So the litigation funding clearly is behind some of the litigation in Pennsylvania. But other than that, I did not encounter things that struck me as I reviewed the literature. In New York, for example, there's big concern about the scaffold law. In Florida, we've got the homeowners, we had the assignment of benefits. In Louisiana, we've got all sorts of things going on, whether or not the insurance commissioner is in office or somewhere else. In California, so some of the most salient trends are in these largest states. But yeah, I didn't see anything that jumped out at me for Pennsylvania, other than seeing the litigation funding firm there solidly behind the Trial Lawyers Association. And then going back to the first thing, the warning that we need to be vigilant and prepared to be surprised. Oh, that's the nature of the beast. On the liability side, the liability form is so broad that it can entertain any number of allegations, and attorneys are clever in finding ways to go into the CGL form or the DNO form and find coverage where it was not intended. And one of the obstacles that we have is that our rate making is backward looking, right? It's like driving by looking at the rear view mirror. Historical data is not necessarily predictive of future losses, because we have these phenomena which happened, the oops effect. Who expected we would have a pandemic? Who expected that we would have technology that would enable people to sue at the click of a button, just make it easy as pie? So there's these new phenomena that we need to be aware of. The Uber and Lyft. Okay, we've got the firms, ride-sharing firms, which are new. And whenever there's something new, you've got MGAs and brokers and insurers saying, okay, this is a new phenomenon. Let's provide coverage for this. We've got cannabis, we've got active shooter, we've got shared riding, Lyft and Uber. So that's an opportunity area. But without the understanding of the potential for losses, we can have ugly situations develop. I mean, look what happened with the Uber account and James River. James River, the specialty E&S company, is on the ropes because of the tremendous losses it got on on its Uber account. Had to raise its reserves. It was downgraded earlier this year. A Virginia company, James River, great E&S specialty insurer. Just a couple of days ago, American Transit in New York, we had outside actuarial firm said that they were under-reserved by $500 million because of their livery and shared riding services accounts. So the potential for losses is something that can make liability a real killer. I mean, it's been the leading cause of insurance insolvency. If you look at the AM Best annual reports on insolvencies in the insurance industry, under-reserved, underpriced casualty business is the culprit. Speaking of under-reserving, there was an RRG in California, risk retention group, Spirit Transportation, that was just hungry for premium, and it was getting premium from from a very aggressive MGAs. It was all top line driven. And in some very large cases, in some very large accidents where it had coverage, it was reserving $100, where the cases were worth about $1 million because they didn't want to present bad numbers. So it's an area with a lot of landmines in there and toe poppers. So it's an area that really requires a good understanding and a very solid rate-making process that looks at exposure rather than loss history, because loss runs are non-existent for some of these new kinds of risks. Yeah, and now, Ron, if I can ask you, or if you've got anything in Pennsylvania that is sort of problematic, the things that I've talked about. Are there any areas that have been stoking the liability or putting Pennsylvania or Philadelphia in particular on the judicial hellholes list that I should be aware of?
Well, there is one area it's in the auto insurance market, and it has to do with a case that was decided by our Supreme Court. It was Gallagher v. Geico, and I'm not the Gallagher. No. And what it did was it upended over 30 years of standard market practice dealing with this concept of stacking coverage. And the law that governs our auto market is a relatively small bill, and therefore it's open to a lot of interpretation. And the trial bar has been very successful at the trial court level and through the appellate courts to make that point, and they've been very successful. And in this particular case, the owner of the vehicle that was in an accident had stacked his auto coverages. He had a separate policy with the same company for his motorcycle, but didn't stack that. And the courts ultimately determined that the company should have been aware that there has been a distinction, that there, it wasn't all stacked, and actually wound up deciding in favor of the plaintiff there to allow the stacking of coverage. So obviously, this is UM UIM kind of coverages. So it's definitely the liability stuff. So that's a big one. And the General Assembly is really challenged here because, as you mentioned, the trial bar has a huge interest in maintaining the status quo now. And the industry itself would like to see reforms. Right now, the reforms are happening through the court system, so it's very open-ended. We don't know how that will happen because it's just very difficult to get a bill through the General Assembly now to deal with this kind of issue. So that's a big one. I think the concept in Philadelphia courts and some other of the more liberal courts in Pennsylvania, you have the issue of just huge verdicts, just these massive verdicts that tend to come out. And of course, across the United States, you have the issue of business interruption insurance. And we've been very fortunate at the federal level. There's been lots of suits at the federal level that have come down in the favor of the defendants. But now they're moving to the state court levels. And that's a little bit more interesting because the states have a different kind of, every state has its own kind of culture. So those are the kinds of things that keep a lot of the commercial carriers up at night, and the claims people up at night, and the lawyers up at night, figuring out how to deal with all of this. So those are kind of the hot topics. There may be others. If anybody on this session has any others to offer, please either send them through the chat function that I'm monitoring or through the Q&A. So sorry I interrupted you so long there, Jerry. You probably need to get back on track here.
No. This was meant to be a discussion, interactive, where we learn from each other. But yeah, thanks for that. But yeah, so speaking of automobile, I'll talk about an issue that is problematic for a lot of personal automobile insurers. I'm sure many of you that are on this call, the book is largely personal auto, and that's right to repair. A couple of years ago, Congress appropriations, Senate and House committees asked for a report from the FTC, from the Federal Trade Commission, to look at practices that are going on in repair markets for automobile and also for other devices, for like things like cell phones. The problem there was that there was suspicion that there was anti-competitive actions where manufacturers, original equipment manufacturers, were requiring buyers of their products to go to them for repairs. They were dominating the repair business. They weren't allowing buyers of cars and smartphones and things like that to go to other kinds of repair shops that are cheaper. And this, of course, drives up the cost of claims and makes automobile insurance more expensive and eats at the profit margin. So the FTC came out with its report, and this is an excellent report. It came out just about a month ago. And if you're interested in right to repair issues, I recommend that you look at the report by the FTC, and the title of it is Nix the Fix. Nix the Fix. It's like a 50-page report, very well written, and it gives the arguments on both sides of the story. And it looks at the law. You've got the Sherman Act, sections 1 and 2, that prohibit agreements that restrict competitive behavior. You've got the Clayton Act. There's an FTC Act. So there's clearly law on the books that prohibits this sort of tying, that, if you buy the product, then you have to get the service from from that same manufacturer. So it approaches a monopoly and anti-competitive behavior. Now, I'll start with the arguments for right. Actually, no, I'll start with the arguments against. It's always a good debating technique to give your opponent's arguments first, and then you can turn them apart to show that you see both sides of the story. The manufacturers, the original equipment manufacturers, say that by having the repair function within their own tower, it protects intellectual property, because if it's in the hands of someone else, they understand how this thing is made, and they can have access to stuff which costs a lot of money to develop. And also safety, and some cars parts are welded rather than glued, and then there have been some accidents where the aftermarket repair shops did things in a way which was unsafe, and people weren't able to escape from their cars. There were a couple of cases there. Also cybersecurity, that if a repair shop does a repair, they may have access to personal information. This is like for cell phones and devices like that. Liability, if something is modified afterwards by someone that's not the original equipment manufacturer, then and there's an accident, then they may be liable, whereas they would argue that if we did the repair ourselves, then we wouldn't have had this. That also could affect their reputation. And they also argue about the quality of service, that their service is better. So these are some of the arguments that they presented. But the stronger argument, and the FTC actually came down pretty strongly in its report, and it says, although manufacturers have offered numerous explanations for their repair restrictions, the majority are not supported by the record. So the FTC did a lot of research. They invited comments from manufacturers and their associations, from repairers and their associations, and the recurring arguments that came up favoring right to repair. One of them is actually resonating today with calls for social justice, that many repair shops are small businesses that are managed by minority groups, and if you restrict their ability to do business, you'd put people disproportionately out of work. Economic and social damage, unavailability of parts, when they would call the manufacturer and say, oh, we don't have these parts, so they can't do their work, or they don't supply repair manuals. Have you noticed that when you buy a device nowadays, you don't get a repair manual, or you don't get a manual of any kind? You just get the device, and you've got to Google the instructions there. You've got to go to the manufacturer. And they don't make the diagnostic software available to other parties. They retain it themselves. They've got designs that make repairs really almost impossible to do. Like if you open the hood of a car, you don't see much anymore. Whereas before we would get at the different parts of the engine, whereas now it's all protected under a sheath. And many other kinds of devices are like that as well, where you just can't get at the innards of something to repair it. Telematics information that's in an automobile, that have information about how the car is driven, is fed to the manufacturer, and the repairer doesn't have access to that. Telematics information that could enable them to do a repair. There's also been disparagement of non-OEM services. Manufacturers will insist that their repair is superior, and others are amateurs. So a lot of kinds of restrictions there that have made repair shops less able to do their work. And this is a battle that's being fought now that the FTC report is out. That's a useful piece of information. So right to repair is an issue which we've been following. And another really hot one, and a very current one, it's been brewing in Washington State, spread to Colorado, and it's certainly coming to other states as well, is the use of information, the use of data for underwriting, mainly for automobile, again, for private passenger automobile insurance. And this kind of data is credit-based insurance scores and other kinds of demographic data on the individuals. The arguments that are being made are that this is a form of proxy discrimination, or discrimination because it's alleged that people with lower credit scores or lower credit-based insurance scores are disproportionately minorities. So this use of this information is something that causes insurance companies to charge more to minorities, and it's discriminatory. So this is something that also involved the FTC. About 14 years ago, it was the FTC did a major study on the use of credit-based insurance scores and to see, is there a correlation, is there causation, is there impact on minority communities, is there discrimination? And it came down with a conclusion pretty strongly, and it was an excellent report. It's another one that's out there that's available, and then people are still talking about it. It found that there is not discrimination in the use of credit-based insurance scores, because there are people with high scores that are poor drivers, just as though there are those that are with lower scores that are good drivers. So Washington has been fighting this for a long time. It didn't pass in the state house or Senate, so the governor took an executive order and ordered it to be prohibited insurers from using credit-based insurance scores or other data. In Colorado, now the bill is awaiting the governor's signature, and this is something that the industry is opposed to because credit-based insurance scores are predictive of losses and do allow for better pricing, more accurate pricing, and it's not discriminatory. Discrimination is poor economic policy. It's not economic. So this is a battle that's heated up, and the most recent development, and it's a current development, is that the Federal Insurance Office, the FIO within the Treasury Department, the FIO has just a couple of weeks ago put out a request for information. They've asked for information. The deadline is July 26th. In case anyone is interested in sending in something, I'm going to write a few pages to try to come down with an even-handed statement on what I think is the case here. But so if you look it up, it's in the Federal Register. It's called Monitoring Availability and Affordability of Auto Insurance. And this is an area that has involved the FIO before, the Federal Insurance Office. They did produce a report on the automobile insurance industry. The FIO does not have regulatory powers. Its marching orders, as contained in the Dodd-Frank, when it was formed within Treasury, are to monitor the insurance industry, to be a source of information of the insurance industry. But now with the new administration, there is the concern that the FIO may try to expand its brief beyond what it was originally tasked to do. And in my view, it hasn't done a great deal. It's put out some reports. Some of the reports that it put out were 2 years late. The original one on insurance regulation, and then the one on global reinsurance. So this is something which is probably going to go somewhere, because people that I've talked to that are close to the FIO indicate that discrimination is an area that is a disparate impact, is an area that they are interested in. So this is something to watch. I know many companies, many actuaries are concerned that their hands might be tied by restrictions on using data, third-party data that can help them to do more granular rating, the way Progressive does with its really granular rating if you look at their filings. So not having the ability to do that would make the job of rate making less successful than it has been. So this is an area that I'm following and that impacts personal auto insurers. Now we've got 5 minutes before 9 o'clock, so if there's any questions, if you can shoot them over to Ron, please do so. And Ron, just cut me off mid-sentence if you get anything. And if you don't get anything, I'll just talk about one last thing, which can also trickle down to the homeowners, and that is what's happening with the Biden tax plan. As we know, we've got expenditures that are slated for infrastructure from the bills that are being bruited about. And one of the ways in which the administration tries to pay for the spending is by having a global minimum tax in other countries, something that would actually cause reinsurance rates to rise because if there's higher taxes in places like Bermuda or Ireland, where many reinsurers are domiciled, then margins will be impacted and rates will have to be raised, and those rates will be trickling down to homeowners. And this is something that especially would affect catastrophe exposed homeowners in places like Florida, the Gulf Coast, the Southeast. So this is an area that we're looking at aspects of the Biden tax plan, the Made in America tax plan, that has got provisions for a higher global minimum tax, and also to replace something that came out of the Tax Cuts and Jobs Act, the BEAT, the Base Erosion Anti-Abuse Tax, to replace that with a new acronym called SHIELD, something that would limit the ability to cede to related offshore entities. So higher costs for homeowners insurance in places like Florida, they're already well above $2,000 on the average. And this could affect affordability for homeowners insurance in many places that are exposed to hurricanes. So this is another area that I'm looking into. So I just want to thank you for spending some time with me, allowing me to spend time with you and talk about some of the things that I'm thinking about, and maybe you'll be thinking about. You'll be stimulated to be aware of as you hear things and read things and think about your company's plans, what impacts on liability books and personal auto from some of the battles that are in the public policy realm. So Ron and Brittany and Andrea, I want to thank you for the privilege of being with PAMIC once again after several years. The last time I saw you was in Nemacolin in Western Pennsylvania. And if you have questions that come up afterwards, feel free to shoot them over to Ron or to me directly. They can give you my email address, and I'll be happy to be in touch with you.
Thank
and
you.
to learn from you as well. So thank you very much.
Jerry, as usual, you've done a wonderful job. And I do have one last question. Would you consider actually speaking at our claim summit in April? It's going to be in person. And usually get about 300 folks at it. So, and all of them are claims professionals from all aspects. And the only reason why I ask that is eventually Andrea has to start planning it, and by that time you'll be a little more ingrained in your new position at R Street and have a lot more stuff published and share with us. So you don't have to give me an answer. It's rhetorical in the sense, but hopefully you'll be able to do that. But once again, I want to thank you as usual for an outstanding presentation, great information, and we look forward to working with you in the future. So thank you, Jerry.
Thank you. And thanks for the invitation for next April.
Yeah, you can start planning now. Okay, so moving on to the next session, which deals with business interruption and back to work operations. So more hands-on kinds of things, and I'll introduce those speakers in a second. But before I do that, I'd like to mention that I want to thank all of our sponsors, from our premium gold to our individual sponsors here, for helping us out. It provides us the financial backing to be able to provide speakers like Jerry, who are world-renowned experts in their field. And through the next break, you'll actually start seeing who our sponsors are. I ask you as potential customers, use them as best you can for the work that you need to get done. With that said, we can move on to the next session, dealing with business interruption and back to work operations. We have two speakers here, two very well-known folks to the PAMIC community. We have Scott Ribney and Dan Twilla. And I do have their bios here. And I do have to say, in reviewing their bios, they're very, very intense and chock full of experience with that. So let me quickly go through them so you have a better feel for the level of expertise that these people bring. So Scott Ribney, who has been a speaker at numerous PAMIC events over the last year and a half or so, is chair of Morgan & Aiken's Insurance Coverage and Extra Contractual Liability Practice Group. He was also one of our key experts in talking about the emerging issue of business interruption insurance back during the early days of the pandemic, and he spoke to us many times on this kind of issue. He represents contractors and construction companies in litigation involving, from varied places, from like New York's labor law, et cetera, to Pennsylvania business. His 20 years of experience, Scott's knowledge of the business of insurance gives him the unique ability to advise and counsel insurers on corporate and policy-related issues, even before, which is always a good thing, the litigation arises. And I think one of the takeaways from Jerry's conversation simply was, you got to keep your eyes open, your ears to the rail to try to predict what's coming down. So having people like Scott and Dan do that. Now, Dan is a litigator who practice focuses on insurance bad faith, insurance coverage, and commercial litigation. He chairs the insurance practice and extra contractual practice group at Burns and White. I don't want to take away from their very, very expansive resumes, but I do want to give them as much time as I can for their presentation. So if I missed anything in this, Scott, Dan, you can fill in the blanks, but otherwise the next hour or so is yours.
Great. Thank you very much, Ron. And good morning, everyone. Thanks for having Dan and I here today to have this follow-up discussion about COVID-19 and kind of where we stand at the moment. Before we dive into that, what Dan and I, as we were planning and getting ready for this, we want to make sure that we do is invite this to be as much of a roundtable discussion as possible. We have some things that we're going to be talking about here that we think are going to be of interest to you, but if there's something that you want answered, then either unmute yourself, ask it, or type the question in the question box, and we'll get right on that. But the more back and forth I think we have, the better all of us will be, because while we know how things are going from the legal side, you may be feeling or viewing COVID differently from inside your respective organizations. And we want to make sure that if you have a question, kind of like what the teachers used to tell us back in elementary and junior high school, odds are somebody else is thinking the same thing and has the same type of question as well. So let's make this as dynamic as we possibly can here. Dan and I started teaming up, just a real quick background, with the COVID discussions not too long ago, because candidly, we're in complete opposite ends of the state. Dan has the western part of Pennsylvania covered. I've got the eastern part covered. And between the two of us, our firms and our attorneys have been following these issues from the very beginning. Okay, so what we're going to do for purposes of our discussion today is kind of talk through with you from a 10,000 foot perspective, the lay of the land right now with COVID, what trends we're seeing among the different lawsuits, what's bubbling at the appellate levels, who the attorneys are. And I think that is going to be an important part as well. But then we're also going to talk about something, and I got to give Ron credit for this, because when he and I were talking, he threw this curveball at me, which I was happy to take. Although at the time I think it was more like a knuckleball because I wasn't expecting it. But it was a real legitimate question. And as I delved into it and Dan and I talked about it, we realized, hey, this is something that merits some discussion. And that is, are there any potential D&O implications for members of your boards relating to COVID? And I think my perception on that has changed slightly, but we're going to get into that as well. Now, so it doesn't seem like I'm monopolizing the whole discussion here. What I'd like to do is kind of kick it over to Dan to kind of talk about some of the developments in the COVID litigations, because candidly and somewhat unfortunately, some of the bad decisions are coming out of his neck of the woods right now, which is not something I think any of us would have really predicted ahead of time, seeing the cases go into litigation. So Dan, let me toss it over to you.
No, I appreciate that, Scott. And thanks again for inviting me to participate today. You mentioned you're in the East, I'm in the West. I might prefer to be in the East because I might have a better shot of getting a decent result on some of these cases if I were. So I kind of wanted to start with a statistic, which is on a national level, but I think it translates to what we have seen actually in Pennsylvania. And that's a statistic regarding the number of dismissals, the percentage of dismissals in COVID business interruption cases in state court as compared to business interruption cases in federal court, because it's really a startling statistic. In state court, only 46% of cases have been dismissed at the preliminary objection stage. In federal court, it's over 90% of cases that have been dismissed on a motion to dismiss. And I think that what we have seen at the state level is consistent with that. There have been favorable decisions for the insurance industry in federal court. I'm not aware of any unfavorable decision in federal court against an insurer at this point in time. But at the state court level, we've seen it go both ways. There are favorable decisions in Lackawanna County, in Lancaster County, but there are unfavorable decisions in, I guess, the state court jurisdictions where you might expect them to be a little less favorable than in those counties. That being in Philadelphia County, there's one decision, but it's not, there's not an opinion associated with that order denying preliminary objections. In that case, has been dismissed by way of a precedent to settle, discontinue, and end. The much more problematic decisions have come from Allegheny County, and in particular from one judge, Judge Ward. And Judge Ward, it's significant that these cases have come from Judge Ward because she is responsible for complex litigation in Allegheny County. She has a number of cases pending before her because she has coordinated all of the state court lawsuits filed against Erie in front of her. And she has 2 decisions issued already, which are unfavorable to the insurance industry. The first is a case called Ungarian versus CNA. It's a dentist here in Allegheny County who operated a business called Smile Savers. I'm very certain that the plaintiff's bar was smiling as a result of Judge Ward's decision in this case, because Judge Ward's decision is contrary to the other decisions that we have seen out of the federal courts and the state courts that have concluded that there is no coverage for business income because there is no direct physical loss of or damage to property at a described premises. And what Judge Ward did in Hungarian is do an analysis of those words. She picked out direct, she picked out physical, she picked out the word damage and loss, and did an analysis and concluded that you don't have to have physical damage to the property at the described premises itself to satisfy that phrase. You have to have, all you have to satisfy the direct physical loss requirement is a loss of use of the property. And she concluded that because of the pandemic, because of the need for social distancing, and because of Governor Wolf's orders, there was a loss of use. That loss of use was physical because you couldn't have physical access to the property, and it was direct. She rejected the argument that the period of restoration had any impact on the analysis of whether there was a direct physical loss of use, because she found that the period of restoration element only goes to the timing. How long is the insurer required to pay? She rejected the exclusion for ordinance or law because she found that the closures weren't only as a result of Governor Wolf's orders, they were also a result of the pandemic generally. And she rejected the application of the microbe exclusion, the exclusion for fungi, wet rot, dry rot, and microbes, because she concluded that under the dictionary definition of microbe, a microbe is a living thing. And because a virus is not a living thing, a virus did not fit that definition. Notably in Hungarian, there was no virus exclusion. And there was no virus exclusion in the other case that Judge Ward decided, which is consistent with her reasoning in Hungarian. That case is McMiles versus Erie. In that case, Judge Ward again found that there was coverage, at least for loss of income. There was a fact dispute as to whether there was coverage under the civil authority provisions of the policy. Hungarian is on appeal to the Pennsylvania Superior Court. There are other state court decisions that are on appeal to the Pennsylvania Superior Court. And there are a number of federal court decisions that are on appeal as well. But I think Scott was going to talk about what he has seen in the Eastern District in terms of recent decisions that have been favorable to insurers and the status of those cases.
Yeah, absolutely. But one thing before we leave your neck of the woods there, Dan, and I think it bears mentioning on the Hungarian decision, because I see this as being one of the places where the courts are going to go next with this. Judge Ward also broadly rejected the loss of market exclusion in the policy. That was argued slightly. She did it. Her analysis of that really paled in comparison to the effort she put into the direct physical loss language. But I'm going to expect this to be a bigger issue going forward. And for those on the call who may not know what we're talking about here, it's essentially an exclusion that doesn't get a lot of publicity, but from my research and vantage point was put into commercial policies with the intent of saying, if you have either a disruption at the beginning of your supply chain or at the end where you can't sell goods to a certain entity. Let's say one of your biggest suppliers or purchasers is Walmart, and they just decide they're not going to carry your good anymore. You can't go to your insurance company and now say, hey, I've lost this business. that's caused me to lose $10 million. I want coverage for it. That's not what it was designed to do. Judge Ward didn't discuss the loss of market, but I think in this particular case in Hungarian, she may have gotten it right because it was people coming to the insured's business. My concern with her decision is her flat rejection of it on a broad scale basis. And she's very broad wording in her opinion. Now, what that means for other claims and the enforceability of that going forward, I think is an open issue, but I'm confident that as that gets to the right courts under the right set of facts, we're going to see courts upholding that more. Here's the other interesting thing, and Dan and I were talking about this, and this is, for those of you who have heard me talk from the early days of this, one of the things that's always been a concern to me is the number of different policy forms talking about direct physical loss. Okay, so if we exclude those cases where you have a virus exclusion, and not everybody does, and even carriers we've seen that have it on one form may not have it on another form, there has not been a lot of attention paid in Pennsylvania's courts, and ideally, I think, Dan, nationally, on the differences between the policy wording on direct physical loss. And by my count, there's about 5 different variations of that. And I think that begs the question, and it may be one that the appellate courts will ultimately decide, does that wording matter? And I think if you follow Judge Ward's reasoning on some level, and she really broke it down into say, okay, direct physical loss or damage. And she used the or as the breaking point to say, okay, you have direct physical for one or this other one. So they're 2 completely separate pieces. Well, if you apply the basic rules of grammar to a lot of these other provisions, in the hands of a savvy property insurance attorney, they can make a compelling argument, I think, as to why some are narrower in coverage than others. So where you have, for example, language that says direct physical loss or direct damage, I would argue that's the most restrictive of all of them because of the word direct in there. Now, in court, I would have to argue more broadly, how it applies across the board. But for our discussion purposes here, and as you look at your different policy forms, that is certainly something to think about, especially when you consider that there's a big event happening in 2022. And that is ISO is completely revamping all of its lines. And I think a lot of other policy form makers are doing the same thing, and they're doing some pretty big changes coming next year. So now would be the time to start looking at these policy forms going forward. But am I kind of right so far, Dan?
I absolutely agree with that. I think that the specific policy language at issue in Hungarian had a big impact on Judge Ward's reasoning and that use of the word or. She reasoned that because of the word or, the policy has to really refer to 2 different things. The loss of use, physical loss being different than physical damage. And so I think that was a pretty big, had a pretty big impact on her analysis in Hungarian. And as you and I talked about leading up to the presentation today, I think that there are differences in policy language. There is an appeal to the Third Circuit based upon some of the federal court decisions that have come out. There are more than, I think there are 15 cases and a number of different insurers with different policy language who are involved in that appeal. And one of the insurers filed a motion to consolidate those cases. And as I understand it, the status of the court's decision on consolidation is pending, but it'll be interesting to see how that plays out in light of the differences in the policy languages and the fact that I think some insurers are going to have different arguments than others.
Well, what's really interesting about that decision is, or by that one carrier, is how many carriers were lined up against an MDL for that very same reason. You know, not that the language is the same, but here's, all the reasons why the language is different and why each case needs to be decided based on its own facts and its own specific policy language. But let me kind of bring into the East, because Dan, you asked the question, how are things going in the East here? And I'd say outside of that one Philadelphia trial court order that I'm aware of, which, you know, it was a typical Philadelphia trial court order, meaning you really don't get a tremendous amount of insight into the judge's reasoning. The courts have been pretty favorable for insurance carriers out here. And I think part of that is, A, the judges taking an honest look at the cases relative to the law. But I think also, B, you have, and no disrespect to anybody on the Western side, attorneys, defense attorneys being very selective in terms of what cases they're challenging by way of preliminary objections versus those that they may be setting up for a motion for judgment on the pleadings, and trying to get some additional facts and clarification in there. Not to bore everybody with the legalese of all of that, but, you know, on one hand, you know, the court gives a lot more deference to the complaint, where on the latter, for the creative lawyer, you can get in some other facts that really will help cement your argument. But I think the other piece here, and Dan and I have noted this as well, is by and large, the people who have been filing these lawsuits, they're not your property lawyers. They're not, it's not to say you can discount them. They're very good lawyers, but let's be fair. Jim Haggerty, who's leading the charge with a lot of these, he is heads and tails the expert on motor vehicle financial responsibility law, having probably developed the cases on it. He's not a property lawyer. Same thing with Scott Cooper, who many of you heard talk at the claims conference. Outstanding lawyer. I give him all the credit for that. But this is not his wheelhouse. Why is that important? It's important because the cases are not being filed, relatively speaking, by the property lawyers. And I want to share with you, because I think it's important, my discussion with a lawyer who's been doing the property insurance litigation for policyholders out my way for probably 40 plus years. And I was talking to him about it, and I said, have you filed any suits? And he said, Scott, if I did, he goes, I could bankrupt the industry. He goes, the people who are filing these claims, what they're missing is the understanding of as to how these policies developed over the years. And it's not something you can just research and learn, but the nuances between not just the policy forms, but the number of different forms out there. He goes, I could make the case pretty effectively why a lot of these should be covered based on kind of what Dan and I was talking about beforehand, the different variations between that direct physical loss language. But his response was, why do I want to bite the hand that feeds me? He goes, I need you, meaning the insurance carriers, to stay in business. And I think that is coming through in a lot of the arguments that you're seeing in the complaints by these non-property lawyers. Again, don't discount them. They're excellent lawyers, but they also lack that foundation that you can only get from being in this type of business for years and years and years. What we are starting to see, though, more now, I will say out east, and this came out in a decision at the beginning of May from the Eastern District, are instances where you have businesses that are not your traditional restaurants or dentists. Now, you know, for example, you had a case involving a vending machine company out here, RDS Vending, where they were actually exempt from Governor Wolf's order. but tried to present a business interruption claim because their customers weren't buying. And that is important because in that type of case, which I see as maybe the next wave here, the court said, look, you weren't closed. So while this pandemic may have been out there, you were unaffected by the order in terms of your business operations. B, no one inside your facility got sick from COVID. Your goods or materials weren't contaminated with COVID. So you're out of court. And I think you're starting to see some clear trends in that regards. But again, until we start seeing decisions out of the Superior Court, which this is the long game for the plaintiffs. They're waiting for the short game here, get through some of these trial court decisions, and then have it be up at the appellate level, where I think it's going to turn the tide one way or another on a lot of these. I'm going to go out on a limb, and Dan, I think you'll join me out on this limb in saying, in those cases where there's a virus exclusion, the carriers are on real solid footing. The question's going to be, though, how much is the appellate court going to go through that first analysis of the direct physical loss, as opposed to saying it doesn't really matter because under this case, you have a virus exclusion and it's out. Now, I think, Dan, you were saying before, your conversations with a lot of the attorneys out by you is they're starting to shy away from even getting into cases that have a virus exclusion.
Yeah, that's right. So, and to your point, in terms of the property lawyers in their pursuit of these cases, my experience has been the same as yours. We have far fewer dedicated, what I would describe as dedicated property insurance lawyers in the western part of the state than you have in the eastern part of the state. And our experience has been, though, that it's really been plaintiffs' personal injury firms and some of the lawyers who traditionally do auto insurance work that have been filing these cases. So my experience is the same as yours, but I think one of those who I would describe as really a personal injury lawyer filed a case against one of my clients a couple months ago. We filed a motion to dismiss. And the day after we filed that motion to dismiss, he called me. And I guess this probably goes to the fact that he didn't really have a lot of property insurance experience. He told me that he was not aware of the virus exclusion. He had not read that portion of the policy before he filed the lawsuit. And he had consulted with, and what he described as an insurance expert, he didn't identify who that was, and that because the policy contained a virus exclusion, he was going to voluntarily dismiss the case, and he did that. I have heard that is the playbook for some of the other lawyers in the western part of the state as well, that if there is a virus exclusion in the policy, that they're not even going to file the lawsuit. But if there is, I think in light of Judge Ward's decision, if there is no virus exclusion, and if they can keep a case in state court, which I think the plaintiff's bar has really made an effort to do, even with some insurers that have diversity jurisdiction or could have diversity jurisdiction, I think they're making those efforts. So that's been my experience. I don't know what you're seeing on the eastern part of the state in terms of cases being pursued when there is a virus exclusion.
I think it's by and large the same type of thing across the board now. There were early efforts to challenge the viability of the virus exclusion. The only situation where I would be nervous, and again, I'm looking more for the appellate courts to weigh in on this, is with the reasonable expectations. Dan, you and I have gone back and forth on this, but I see that as the one potential place where the appellate courts could, or even a trial court, get around the virus exclusion, but it's got to be pled well. It just can't be the generic boilerplate type allegations. But in Pennsylvania, it's one of those few states where if an insured reasonably relies on something that they've been told by an insurance carrier, that will completely avoid even the clearest exclusion in a policy. And the courts traditionally have limited that to non-commercial entities, but there is one case out there, and I believe I found it at one point was out of the Superior Court, that seemed to open the door up to a commercial entity. But beyond that, even if I put that aside for the moment, and, you know, when I say commercial, the first thing that pops to my mind is your big box chain stores, you know, your Targets, your Best Buys, the mall type places. But what if I have, you know, and this is the case that scares me and keeps me up at night, your mom and pop deli that maybe they're trading as, you know, Janine's Bagels, but it's Janine and her husband, John. They're not incorporated, but they're doing business as Janine's Bagels. Well, it's a business. Does the reasonable expectations doctrine apply differently because technically it's the two individuals as opposed to an LLC, an incorporated entity? I would argue no, but I think you would get a real sympathetic ear from a judge who said, look, these are your neighbors. You know, they're not savvy in this. You know, they should be treated no differently than a regular insured having a homeowner's insurance claim. And then when the door cracks that much, then, you know, you give a mouse a cookie, they're going to want a glass of milk with it, as the old adage goes. And I think then you start seeing it snowball. What do you think, Dan?
Well, I think those are all great questions and points, and I think the sympathy factor could play a role. I mean, when the pandemic first started, we had Congress and certain state legislatures calling for insurers to be required to provide business interruption coverage, even if their policies didn't obligate them to do so through legislation. And so I think that is a concern. I think we are on pretty good footing in Pennsylvania with the reasonable expectations issue, because I think the law supports that unless the policy is really ambiguous, that that doctrine does not apply. But I think it's a great question. For example, you know, one of the points you raised is if the policy conflicts with something the agent or the insurer in the underwriting process may have said to the insured, or if the insurer has not sent a copy of the policy to the insured. I think there are questions and there are issues that can be raised there. To that point, there was, you know, and this is really a claim under the UTPCPL rather than, you know, a claim for coverage. But we had that Gregg case last year, which basically said that any representation from an insurance agent that has the possibility of causing confusion can give rise to a claim under the UTPCPL. And I would not be surprised to see cases alleging that, you know, the agent told them that there was, you know, soup to nuts coverage for business interruption claims and those types of things, where the insured is going to say, based upon those communications, I thought this was going to be, I thought this would be covered. Obviously, you know, the exposure to the insurance industry for these cases, there's a reason for the exclusion, and whether the insured has an expectation based upon the fact that they've had a loss, whether that expectation is reasonable or not, I think we can all argue about, but I wouldn't be surprised to see those arguments made.
Now, here's also, I think, where the rubber hits the road as well. For those of you out there who have 1-year suit limitation provisions in your policy, you're probably breathing a big sigh of relief now, by and large, because if it's a government ordered shutdown and you can go back to the date of the original order, which is in March, you should be pretty clear of any additional lawsuits. For those of you with a 2-year suit limitation, you've got 9 months left. If we look at the current track of some of the appellate cases, we might get a decision, like a written opinion out of some of those by, what do you figure odds are? Maybe November, some of these first ones filed? Like Hungarian that's going up there, Dan, or the other one? Because they don't have briefing schedules yet, I think, on it, do they?
That's right. I don't think there's briefing schedules. Actually, I think there is a briefing schedule in Hungarian. No briefs have been filed yet. I think there's a briefing schedule set, but I would be surprised. I think it would be very difficult to get a decision out of the Superior Court within the next 6 months or so. So I think there is going to be that kind of a tight window between that time period and the 9 months you've referred to, in terms of whether we might see an increase in cases at that 2-year mark.
Right. Now, I want to switch gears for one moment, because I think, and Dan, you can tell me if you're seeing the same thing as well. And Ron, if you want to jump in, I'm going to pull you into this discussion as well. But I think, given the number of decisions that have come out in favor of the carriers, one indirect side effect of that is we have not, at least I've not heard of a lot of, we'll call it investigations by the Department of Insurance into different carriers' conduct. I'm going to attribute that to the overall success of the carriers, that they're not getting involved the way maybe they might if the decisions had swung the other way. But Dan, are you hearing anything out on your side or with your clients? Again, not divulging any confidences, but.
Yeah, I have not heard of that.
Okay. Ron, are you hearing any rumblings over there?
No, I'm not. In fact, I would argue that even though I would say this department is a little bit more activist than we've seen in the last couple of administrations, the Unfair Claims Practices Act is, from a regulatory perspective, is more about process. Are you giving appropriate notice and those kinds of things? But that law does allow for the private right of action. So if the complaints aren't coming in that they're not giving the appropriate notices at the right time, there'd be no reason for the department to want to weigh in on the specific aspects of any particular case. When I was sitting at the department, in the role where I had to make these kinds of decisions, I was always concerned that some side, it doesn't matter if it's the policyholder or the insurer, would want to use the findings of a market conduct exam or some other type of thing in some way in a court proceeding. So we were very careful when we were looking at these kinds of issues, on a go-forward basis. But I have not seen anything with this administration related specifically to the issue of business interruption or the policy language themselves. And remember, on these types of policies, these are commercial policies. They're generally file and use for larger entities. So the department does have the right to look at them retrospectively, but I have not seen nor heard of that happening at all. And in fact, the department, if you go back in history, a lot of these more modern exclusions came out of the SARS, the avian flu issues back in the late 2000s. So there's been, I think, clearer language put in these policies as well in that period of time. But that's a good word of caution for our insurers is, if you have older commercial policies out there, it may be the time to start looking at the language and seeing if you need to update those appropriately, either on a new business perspective or on an existing business perspective.
Thanks, Ron. Now let me paint a worst case scenario, and this ties into the question that Ron threw to me when he first, I first started talking about this presentation a couple months ago. Assume, just for our argument's sake right now, that the decision started to go the opposite way and the courts were finding coverage under these policies. And you have a policy holder who files a Department of Insurance complaint that basically says, in a nutshell, hey, I tried to report this claim. The carrier wouldn't even assign a claim number or open a file. They just denied it, and I got a generic letter. Now we're talking policy or actual procedures within the carrier. That might be something that catches the department's eye. I raise that because when you consider the volume of claims that were out there that a number of you have seen, just whether it's in Pennsylvania or collectively, one of the grounds for a D&O suit is where they arise out of regulatory investigations tied to conduct of a company. So let's say a Department of Insurance, because of the volume of claims, now you have a very significant fine. And again, this is just all speculation now. Might that give rise to a potential D&O claim? If it's large enough, theoretically, yes. I think there's that possibility out there. Have I seen one nationwide? No, and I did my darndest after Ron, posed this question, and I tossed it over to Dan to see if I could find any indication out there where that has occurred, and the answer is no. I have not seen that yet, but let me talk about some other potential D&O risks here right now, okay? And again, this is with the same caveat. I have not seen a lawsuit filed against a carrier for any one of these, but if I put on, my thinking cap and I say, all right, how would I do this if I was on the other side of the aisle here? What types of things would I be looking for? I'd be looking for situations like the first one. Is there any type of regulatory investigation, maybe even at the federal level, where now it impacts either your company's stock, if you have stock, your valuation, or if there's a fine? That's one potential situation. Was there some type of failure to comply with workplace laws? I mean, we see that typically with other companies out there, but when we talk about potential grounds, that's another one. Was there a breach of a fiduciary duty resulting in financial losses? Now, many of you are probably scratching your head saying, I'm not seeing how that one would play out here. Let me give you an example, okay? There are some carriers out there that are part of an unincorporated reciprocal insurance exchange. Okay, they still exist. And for a brief history lesson, those came about because 4 businessmen who were insureds back in the 1800s decided they weren't getting fair rates. So they created their own exchange where they agreed to share the risk amongst themselves. They're unique. They're a special type of entity because the participants, the subscribers, the insureds, are also, you could think of it this way, part of the insurance carrier, but also esoterically, you could say they're also a part owner in the company, much like a stockholder is. And I'm not aware, in fact, there was one comment in a Texas case where the court said that it was not aware of any D&O cases where a reciprocal insurance exchange was found to have owed a fiduciary duty to its subscribers. But just because a court hasn't ruled on it yet doesn't mean that someone can't be creative and come up with the argument to say, okay, if one of these other three things I talked about beforehand happened, and you're a reciprocal insurance exchange, could a policyholder have standing to bring that lawsuit like a shareholder could against a company for certain losses? I can't rule it out. Do I think it's a stretch? Yes. Would I like to be the one, if I was a plaintiff's attorney, to try and make that argument? Sitting here today, probably not. Because I think those are long arguments and hard arguments to make. But again, if the purpose of this call is to say, okay, what's out there that you should be aware of? I would say on the D&O side, probably not much. I mean, the odds are, very long. You probably have a better chance of hitting the Powerball, I think, right now than, having one of these types of claims. But just because the odds are long doesn't mean it can't happen. But from everybody I've talked to, I see the list here of attendees, even those, member companies who are not on this call. I've got a high degree of comfort in how you conduct your operations, that I don't see these as being really big exposures or the types of things that you or your boards should be up at night worrying about. Dan, have you seen anything different? I think when you and I were talking beforehand, you hadn't really seen much, one way or another on this.
I have not, and I don't have a ton of experience with D&O litigation, and I think you've taken a much deeper dive on this issue than I have. But I have not seen anything out there that would concern me. I know that basically from the D&O perspective, when COVID, when there were first discussion back in last March and April about the impact that COVID might have on the insurance industry, there were concerns about the exposure. If these cases went the wrong way, what would the impact on a company be? What obligations might an insurer have to disclose, on a forward-looking basis, those risks to its shareholders? Those types of things could raise questions. I know that there was a lot of talk about rates going up, D&O rates, because of exposure in particular industries, including the tourism industry, pharmaceutical industry. But I haven't seen anything in terms of D&O litigation against any insurance company at this point, or any real reason for concern other than what you've already identified.
Okay. Now, in terms of things that do keep me up at night, I want to go through some of those in the last 10 minutes. Dan and I, Dan can chime in as well and offer his thoughts as it relates to this and some of the indirect impacts. The first thing that is concerning to me is the amount of judges in Pennsylvania who are now punting these types of efforts by carriers to remove coverage disputes to federal court. I think that's something that's going to have a much bigger impact on you going forward because, let's face it, by and large, as Dan pointed out before, the federal judges are more favorable to the insurance carriers. Well, if now they are going to start using this remand as more of a weapon to keep their dockets lower, you're going to be forced to litigate in unfavorable jurisdictions. And part of that decision, I'm sure, was grounded in the rush to remove every case to federal court. And there was going to be some blowback eventually to that. And that's one side effect. The second side effect, and this is where Dan and I differ in opinions, and that's okay. But the thing that also keeps me up at night from a bigger policy perspective is, what does the appellate court do with that reasonable expectations argument? Because I guarantee you that is going to be addressed by some appellate court as it relates to these COVID cases. And even if it's a decision that says you need facts developed before we can make a ruling on that, that's going to be interpreted as a business can now assert a reasonable expectations argument. That's going to open up your books and your litigations for those types of claims potentially more. I hope I'm wrong. I pray I'm wrong on that. But again, that's something that is concerning to me. And then the whole direct physical loss argument. I see that as one that's not confined exclusively to the commercial policies. And I think if the courts start opening that door up in terms of how they're interpreting it, it's going to bleed over into the other lines as well, your homeowner's insurance line, and risks where you may not have had coverage before because it wasn't a direct physical loss. Now there may be some more exposure there. Again, I hope I'm wrong. I hope the courts stay true with what Dan and I have been arguing all along here in terms of you need to have a physical change to the structure itself, you know, where it's damaged, not this more amorphous type ethereal concept of damage, but, you know, something you can see, feel, and touch. Then I think we'll be in good shape and I'll be sleeping much better at night. Dan, is there anything that you see potentially on the horizon here that you say, you know what, these are things that I would be on the lookout for or I would be concerned about? Because again, all of us on this call, you know, we're interested in managing risk. And even if that means, okay, trying to plan ahead for something.
Well, I think that we've seen a slowing of filings. I think we're seeing less filings over the last couple months. I think, you know, I doubt it would surprise anybody on this call to hear that, you know, we don't have a insurance industry favorable appellate court system right now. So, you know, I don't know what to expect from the Superior Court and ultimately from the Pennsylvania Supreme Court. But there's a reason that Jim Haggerty tried to get this issue, the business interruption issue, in front of the Pennsylvania Supreme Court with his King's Bench petition at the very beginning of this litigation. And the Supreme Court declined to take it. But at some point, it's going to work its way there. You know, hopefully, you know, at least in cases, especially in cases in which there's a virus exclusion, you know, the plain language of the policy is going to apply, and the exclusion will be applied. Hopefully, the insurance industry's arguments regarding direct physical loss are accepted by the Pennsylvania Supreme Court. But I think there is a ways to go before we get there. And then just with respect to, you know, your comments on the strategy of keeping these cases in state court, I think my experience and understanding has been that that really is a Haggerty-Cooper strategy. And what they have done is filed lawsuits in state court against insurers who would be diverse, would have diversity jurisdiction with only one count, and that's a count for declaratory judgment. And some of the judges, well, the Third Circuit has said that you know, district courts have discretion over whether to accept those cases or not. And the argument is, well, it's really a claim for money damages. It's not really a claim for declaratory judgment. It's really a claim for money damages. That's the issue that's been argued to the Third Circuit. It'll be interesting to see how the Third Circuit comes down on that issue, because I think, you know, if those cases are remanded to state court, again, those insurers may see less favorable results than they would otherwise.
If anybody has any questions about anything, again, feel free to chime out. Let us know. We're coming towards the end there of our time. What I would say in terms of, some concluding thoughts. Okay, I'm going to take about a minute or so and just kind of go over, my takeaways from all this, and then, I'll let Dan go and, bring us all the way home here. The big takeaways are carriers are doing well. Let's just give the props to that. The policies are being applied as they were intended on being applied. That's a good thing here. There are some anomalies here and there. Those are to be expected, but in the big picture, the carriers are standing in the right. The claims investigations that were done, aren't being vociferously challenged. So you're making out okay with that as well. Am I a little bit more of a worrywart? I am. I'm a defense attorney. That's kind of how I view our role here, is to, worry more so you don't have to, so we can predict what's going to be coming. But the arguments are, I think, overall sound. They're legally justifiable, and they're based on a lot of long-standing history within the insurance industry. Now, that being said, I would also encourage you, and I've said this to my counterparts at different defense industry events, when you're dealing with these cases, to make sure you are asking having your claims folks follow up with whoever the lawyers are who are representing you about whether the arguments that they're making are consistent with those being made in other litigations by the similar insurance carriers, because the nuances of the policies, I think, are still going to play out at the appellate level. And it's best if, to the extent possible, counsel are on the same page with what they are arguing here. Okay, I'm not saying the carriers need to be talking amongst themselves, but certainly your attorneys can be. And if there's another argument out there that can be made, it behooves all of us to know that, so that we can adequately protect your interest as well. And lastly, that light at the end of the tunnel is getting brighter for all of us. 2 years suit limitation is going to be up soon. We'll be able to hopefully close the books, if not all the way, almost all the way on this COVID from the claims and litigation standpoint, and go see what fun awaits us next. Dan?
I don't have anything additional, Scott, other than to thank you and Andrea and Ron for inviting me to participate. I think it was a good discussion and appreciate it. I will echo your comment. I think the reason that you and I started talking is because, there is a need for defense lawyers to communicate on these issues. And, I think that's been helpful to me. I think it would be helpful to the defense bar moving forward. But that's really an issue that you and I have talked about more than something that I think PAMIC would be interested in discussing. So again, thank you very much. I appreciate the invitation.
Yeah. But the last thing I'll say just on that point, Ron, before you chime in, is for those on the phone, that is actually something Dan and I are really working to spearhead within some of the defense organizations in Pennsylvania, is getting the lawyers to talk to each other more. Kind of how it was, I'll say, when I started practicing, 20 years ago. There was a lot more communication about, arguments and strategies, because the focus was on you, on the industry. And that's what we want to make sure we bring back. So we're leading that charge with the opposite ends of the state. There are going to be others that are going to join into that as well. So with that, I'll shut up. Ron, you can chime in now. And thank you very much, everyone.
Well, thank you, folks, Dan and Scott, for a great presentation. Oh, always interesting. The world of litigation is always a hot topic. Business interruption, obviously, a hot topic because of the pandemic. It's good to hear. And something I learned is that there is a window that is starting to slowly close on when you could bring lawsuits. So that should help a lot of us in this industry sleep better at night. As time goes on. In your comment with the industry, especially defense counsel talking, I am aware of both the Philadelphia and as well as the Pennsylvania Defense Institutes, which is the whole purpose is to sort of bring people like you together to talk about common issues. But it's also a forum for organizations like the trade associations to get involved in these discussions and talk about filing amicus briefs to help educate the courts on this kind of thing. And we've all been very active over the course of the last year. And I would like to say our activity has led to some very good decisions, and we'll keep up that good work. But once again, thank you, folks, for taking time out of your schedule to talk to us, and I do appreciate it. At this point, we are going to take a short break, about a 15-minute break. It's 10:01 a.m. So we'll reconvene at 12:15. And we'll start with the next session dealing with insurance-specific performance metrics. So maybe for the lawyers, this isn't the most exciting topic, but for the insurance professionals that are on this call, this is definitely an important area. So with that, let's take our 15-minute break, and we'll reconvene at 10:15.
Take care, everybody.
Hi, I'm Angie McPhee, Managing Partner of Baker Tilly's Consulting Practice. Transformation has deeply accelerated over the past year, and insurers have even more pressure to modernize. Insurance organizations know new technology, systems, and processes are necessary to maintain market share, ensure their company is sustainable, and be agile enough to manage in changing global economy with changing risks. But how do you manage the change, transform in sustainable but agile ways, and maintain or grow profitability? Our team understands the challenges inherent in large transformation projects. We work with you to help manage the people and process change, but also to understand what truly needs to be transformed. For example, we've developed a technology to help with large pain points in commercial business interruption claims, claims management, and calculation. Here's one way we are helping insurers with technology-enabled services.
The commercial insurance industry has been behind the curve with respect to modernisation, but recently technology is transforming the way insurance claims are resolved. And for insurance companies dealing with business interruption claims, innovative new platforms are making calculations faster and more data-driven, which is certainly a good thing. But if you're an insurer, machines can only get you so far. Baker Tilly knows the human connection is every bit as critical. With Quantum, technology and humanity are in balance. The seamless, data-driven solution you need, plus the hands-on, personalised service that makes the whole process pain-free. Thanks to a Baker Tilly team with over 40 years of global forensic accounting experience. We know you need to differentiate yourself from the competition. That's the whole game. And Quantum can deliver like nothing else. All the benefits that add up to a better experience for you and your policyholders. Quantum is the future of business interruption claims.
New England Asset Management, NEAM, was built to serve the unique needs of insurance companies. We've just focused on building out our people, our technology, nurturing our culture, developing our product and our capabilities.
We create highly customized solutions for each of our individual insurance clients.
We think there are universal aspects to being from New England that translate whether you're in Bermuda, London, Europe, or the US.
I think about wholesomeness, I think about hardworking people.
We want to be known as that partner that's easy to do business with, that understands them, and it's someone that they can trust.
We want to be thought of as your thought partner, part of your success, your investment department down the hall. We remain true to our roots here, remain true to our insurance focus, our dedication to purposeful partnerships.
And that continues to be our focus today. We are New England Asset Management.
Hi, my name is Chris Ellis with Berkeley Re Solutions. You know us from doing casualty treaty, programs, as well as custom turnkey solutions. And we're proud to announce that we've recently launched workplace violence for commercial lines and violent event protection for personal lines. Unfortunately, we live in a world where violent events are all too common, and we all worry about the safety of our coworkers and our family, whether they're at home or at work. And while you can't prevent the unknown from happening, we are proud to be part of a solution set that allows us to be able to take care of both family and coworkers. And we developed this program in partnership with many carriers like you, including some PAMIC members. And they helped us focus on the right coverages, the right service, and the right price points. We like to refer to this as changing times requires changing coverages. Now, we've been proud PAMIC members for over 20 years, and many of you know our key staff, including Tom Greenfield and Kathy Patton. We've always benefited from PAMIC's community, education, and again, we are honored to be part of the PAMIC community this year. We invite you to go to our website and check out those new programs we talked about, workplace violence for commercial lines and violent event for personal lines. Thank you again and enjoy the conference.
Hi, Ivo Raguzzi, owner and president of Optima Security Services, known as Optima SIU. We've been in business for well over 20 years, and we have serviced the insurance community during that entire time. This is our only line of business. Your 100% solution to all your SIU issues. We take care of it all, which separates us from the pack. We can take care of your fraud plans, your annual reports, your mandatory reports, and most importantly, your training, along with all the investigative needs that you may have. Our reach is throughout the entire United States and Europe. We have handled investigations all over the place, including Alaska and Hawaii. You can come to us. We have experts located throughout the country, capable and able to handle any investigation requirement you may have. I have a fabulous team of experts who have been at this for many, many years, and we're ready, willing, and able to help you in a very professional manner to handle all of your SIU needs. Our experience has shown that we are far more cost effective than an in-house operation. We are truly cheaper, generally about 50 to 60% of the cost that you would have to pay for an in-house team. You know us, you know what we can do. We've presented at your seminars, we have given you information, free tips, and we're always available to you just for questions. Call us at any time, and we're here. We are truly insurance fraud experts.
Well, good morning, folks. We're about 2 or 3 minutes away from starting our next session. You still have a chance to take your coffee break. We look forward to seeing you in about 2 minutes.
Loudon Mutual's been very blessed with a lot of growth. We started out as the mutual fire insurance company of Loudoun County. We wrote policies in Loudoun County. And over the last 10 years, we've gone on a large growth spurt. Our operation has become much more complex. And also the regulatory environment has gotten more complex. Our previous firm was a local firm. They're great folks, and they're very good at understanding small businesses, but they didn't have an insurance background. They didn't understand the specific nature of statutory accounting. And what we were attracted to Brown Schultz was they brought a strong insurance background. Not only did they understand the insurance accounting, statutory accounting, they also understood small to mid-sized firms like us.
I was new to the insurance industry, and Brown Schultz was very helpful in helping me with that transition to make sure that I understood all of the insurance-specific reporting required under statutory basis.
Well, just as Loudon Mutual is, we are neighbors helping our neighbors, Brown Schultz is very much involved in the mutual insurance community, and they're there to help companies like Loudon Mutual succeed.
Even though geographically we're not located down the street from Brown Schultz, I've never had any issues being able to connect with them. They're very responsive.
I think one of the unique things about Brown Schultz is the fact that their senior people have such deep experience. Generally, you only find that kind of experience and that kind of expertise with the very, very large firms. But they're small enough that we can work with them, they're personable, we can get in contact with the principals, and they're just a really good partner for us.
I've been most impressed with Brown Schultz with the people. They care a lot about what they're doing as well as about their clients.
I would say Brown Schultz is the right fit and the right balance for companies like Loudon Mutual. We get the large firm experience with having the small firm touch.
Brittany is our technology person, and she could not have timed that last segment any better because our next speaker is from Brown, Schultz, Sheridan, and Fritz. We have Jeffrey Clippinger, who happened to be one of the stars of that commercial as well. Hank, you look pretty good as well, but I know who did all the work for that. So Jeff, I do appreciate it. Jeff's presentation today is going to be about insurance-specific performance measures. So this is something obviously that all of our members and anybody who's interested in our industry will find very, very useful. Jeff has been with Brown Schultz for, I guess, about 10 years or so. You can correct me if I'm wrong. He serves on as a member of the firm's Audit and Accounting Committee. He has over 10 years experience, there you go, specializing in providing accounting, audit, and focused advisory services to the P&C industry and alternative risk management industries around the Mid-Atlantic. Jeff is a member of the Employee Benefit Plan Management Group. In that role, he advises clients and assists in all phases of compliance and advisory services to our employee benefit clients. The other probably most important point I want to make is Jeff is also a CPA, obviously, but he's also a Penn State grad, and I have to like that because I'm also a Penn State grad. So Jeff, there's one other reason why I like you. And with that introduction, I'm going to turn the podium over to you for the next hour or so, and please, it's all yours.
All right, thanks, Ron. I certainly appreciate that. And yeah, I would tend to agree. The timing of that video was fairly spot on. I wasn't aware that was going to play. So thank you to you, Ron, Andrea, Brittany, for the invitation to speak this morning. And I would agree. I mean, this is certainly an important topic. I will warn you that I'm working from an operation that I don't normally work at. So I'm dealing with some spotty internet connection, got a landscape crew around me that's probably locked me 3 or 4 times. So I'll do my best to keep up the quality of this presentation, but bear with me if I do experience any difficulties. With that said, we are going to be discussing the insurance-specific performance metrics. I try to gear this towards board members, but I certainly think that key executives who might not be as closely dealing with financial reporting in the background will certainly get some key takeaways from this presentation. I also wanted to add about Brown Schultz, and we've been dealing with the property and casualty insurance company for well over 5 decades now. And I've personally been involved with and auditing P&C insurance companies now for 13 years. So this certainly is a topic that resonates with us. I think we as auditors, regulators, management, board members, I think we would all agree that the cornerstone of solvency measurement is financial reporting. So with that said, the objective of this session is to provide a higher level insight into insurance-specific performance metrics. And I hope you'll get a better understanding of the numbers behind financial and operational performance. Ron, I'm going to minimize the Zoom screen, so not to discourage questions, but as is come in, please type them. Ron, feel free to interrupt me, so I won't be able to see those. And at this point, I'm going to attempt to share my screen.
Will do.
I will switch that real quick. So hopefully everybody can see the full screen here. We'll move ahead to the agenda. As we were kind of thinking through how we should organize this, we certainly didn't want to spend an hour going through super technical definitions of ratios and metrics. I don't know if that would be the most exciting hour spent. So what we decided to do was kind of give a little bit of a story of those who aren't as familiar with statutory reporting. how to understand the differences between what might be more familiar in a GAAP reporting basis. So we'll highlight some of the key differences, the common differences. We certainly won't highlight all of them, but more of the common ones. We'll provide a little synopsis of what the 2020 U.S. property and casualty industry results were. We'll go through some of the rating agencies that are out there, some of the metrics they use, some of the regulatory metrics that are out there and well cited. And then as time permits, we'll go through some of the annual statement filing key pages that we think could maybe be a resource to an individual who's trying to learn or the statutory basis of reporting. So to kick off, we'll do a comparison of GAAP and statutory accounting. Statutory accounting is promulgated by the NAIC, or the National Association of Insurance Commissioners. And the NAIC utilizes accounting and a reporting framework established by GAAP. GAAP pronouncements that are not applicable to insurance companies are just not adopted by the NAIC. For those principles that do not differ from GAAP, the NAIC must specifically adopt those GAAP pronouncements to be included in statutory reporting. And GAAP pronouncements do not become part of statutory until and unless adopted by the NAIC. So I think why that's important is, when you hear publicized pronouncements coming out from the FASB and GAAP, those don't always reach statutory accounting. As an example, probably the most discussed topic as of late has been revenue recognition. And that's certainly been a key item for manufacturing companies, construction companies, or for insurance companies. By and large, most of the GAAP pronouncement that came out was just flat out rejected, specifically for private companies, statutory reporting entities. So there was already a basis of accounting that the NAIC was comfortable with. Revenue continues to be recognized over the duration of the policy. So for all the publicity of revenue recognition, when you're reading a statutory basis financial statement, it's the same now as it was before that standard came out. Additionally, statutory requirements not only differ from GAAP, but can also vary from state to state. So as an example, certain states may prohibit or limit the amount of exposure in equity investments, whereby if your equity exposure exceeds a limit, potentially a company would be disallowed to purchase additional equity securities, or if the excess is due to unrealized gains, they may actually be required to realize those gains. So again, there's some state-specific practices that can differ. So when you're comparing different states' financial statements, you could see some differences in ratios and results because of those requirements. Ultimately, the objective of GAAP reporting differs from the objective of statutory accounting. GAAP is designed to meet really the varying needs of several stakeholders, investors, creditors, and other users. And the primary metric that they operate off of is matching revenues and expenses, whereby statutory stresses more of a more conservative basis, a liquidation basis, measure of accounting, focuses on the ability to pay claims in the future. Statutory places an emphasis on solvency for the protection of policyholders, and that companies maintain an adequate or safe margin of capital and surplus at all times. It's an accounting model that's based on the concept of conservatism and consistency. It limits the admissibility of certain assets and costs, such as policy acquisition expenses, which we'll touch upon a little bit later, which are effectively charged to expenses immediately. So with that said, I think we'll go ahead and start diving into some of these GAAP to stat differences. Again, these are the more common, more significant differences that you'll see when you're comparing the two sets of financial statements or the two bases of financial reporting. We'll start with investments. Some similarities between GAAP and statutory. Common stocks and most preferred stocks are going to be valued similarly at fair value. Your real estate owned, so your home offices that are occupied, are carried at depreciated cost. And invested real estate is valued at the lower of depreciated cost or fair value. Looking at some of the differences, and this is a fairly new one for stocks that came into effect 2019, whereby for GAAP reporting entities, unrealized gains or losses on your equity portfolio are now recorded through net income in GAAP. However, the NAIC took a look at that and was comfortable with what the current reporting was for statutory reporting, where they wanted to retain that market fluctuation directly through surplus. For bonds, there is a difference in the basis of reporting between statutory and GAAP. For statutory, bonds are valued based off of the NAIC designation and effectively carried at amortized cost for NAIC 1 or 2 securities, whereas everything else would be valued at the lower of fair value or amortized cost. For GAAP, effectively for insurance companies, depending on the purpose of the security, I would say in most cases, bonds are carried at fair value. So just with those two principles, I think you see for a GAAP reporting entity, you see a lot more fluctuation with the market of both your bond and your equities running through either your income statement or your other comprehensive income. Whereas for statutory reporting, that change in fair value is a direct hit to your equity. So when you're comparing ratios on your income statement, that certainly will be a difference comparing the two bases. Continuing on with investments, looking at affiliated common stock, which continues to be a prevalent item in the industry with mergers and acquisitions and accounting for affiliations and acquisitions of like entities. For statutory basis, they've listed on the market exchange, you use fair value. If it's an investment in an insurance subsidiary, you use your statutory equity. The investment is in a non-insurance company, you use GAAP equity. And for GAAP, effectively what you do is you look at the level of ownership and control. And if you ultimately own and control the entity, you would consolidate that subsidiary into your financial statements. That consolidation concept generally is not a concept for statutory reporting. However, if permitted by your state, you could potentially do a combined financial statement that would look similar to a consolidated, but there certainly would be some nuances there. So again, if you hear the concept of consolidated financial statement, it's more of a GAAP concept than a stat concept. Moving ahead, so probably one of the larger or more talked about difference between statutory and GAAP would be the non-admission rules. Various assets created for statutory reporting are just simply non-admitted assets. So they're effectively written off your balance sheet and charged directly to your surplus. Agent balances or receivables, anything aged greater than 90 days are just non-admitted assets. So you can't take credit for that on your balance sheet. For GAAP, you would be able to recognize those over 90-day receivables and effectively evaluate those for impairment. And if there is an impairment, you would set up an evaluation allowance for uncollectability. So a little bit more of a strict and conservative rule, straightforward rule for statutory-based filers. Furniture and equipment for statutory, non-admitted assets. For GAAP, obviously those stay on the balance sheet at historical cost, and you depreciate those over the estimated useful life. EDP equipment, probably one of the more significant line items that we're seeing in company financial statements anymore. Specifically, with legacy system upgrades or replacements or conversions. This is a significant line item for insurance companies. Fortunately, there's been some recent updates to some standards, SSAP 16R, which did provide some clarity and relief to a degree for insurance companies who are developing software. There's potentially the ability to not have to expense that immediately. You could capitalize that and defer that over the useful life of the asset. However, as we have noted on this slide, it ultimately would be a surplus neutral event, because even if you were to capitalize that asset, put it on your balance sheet and defer the expense, that asset would still hit your surplus immediately. So you would get potentially relief on some operating ratios on your income statement. However, your surplus would be hit right away. For GAAP, obviously your EDP equipment would be capitalized and depreciated. Then likewise, unsecured loans would be not admitted for statutory. Effectively, the reason for this accounting treatment is regulators, again, are really concerned with the solvency and the insurance company's ability to pay claims. So effectively what they look at is, for any of these assets, would these be readily available and transferable to cash to pay these claims? And in these instances, we do not think that's the case, so they would be immediately taken out of surplus. Other assets, comparing GAAP versus statutory accounting, prepaid expenses, which can be a substantial item on GAAP basis financial statements, or capitalized. Again, for statutory accounting, they're effectively not admitted. So you're taking the surplus hit immediately when you prepay that expense. And then probably the largest or most material difference between a GAAP basis balance sheet and a statutory basis balance sheet would be the concept of deferred policy acquisition costs. And again, I think this lends itself to the conservative nature of statutory reporting. So for GAAP, costs associated with renewing and writing your insurance contracts are capitalized. And those expenses are actually matched with the revenue of the insurance contract and deferred. And such costs would include commissions, premium taxes, underwriting expenses, and other policy issuance costs. Under statutory accounting, there's a significant drag on your expenses because all of those expenses are immediately recognized. So as soon as they're incurred, they hit your income statement. Compared to a GAAP, right, which you could defer that over a period of time. So when you look at a GAAP basis financial statement, you could potentially see anywhere from a 10% or a 20% deferred acquisition cost asset compared to unearned premium liability sitting on the balance sheet, which could be substantial. Generally, kind of what would be the significant difference between that would be what your commission rates you're paying at, whether or not it's a 10% commission rate across your book or 15% would determine whether that acquisition cost asset would be higher or lower. So again, that's a significant item, significant difference when you're comparing the two sets of financial statements. Another concept would be expense reclassifications. On the income statement and on the balance sheet, statutory accounting uses more of a net model, a net reporting model, whereby assets, liabilities are usually net of reinsurance, and GAAP is more of a grossed up presentation. So some examples here: self-rent charged on real estate owned and occupied by a company is recorded as an investment income and rent expense. For GAAP, that's not recorded, and I'll touch upon that a little bit later. Depreciation of real estate owned and occupied by the company, it's netted against investment income. For GAAP, reported as an operating expense. Your interest expense netted against investment income. For GAAP, reported as a separate expense item. All these items are going to impact ratios on a GAAP basis versus a statutory basis. Moving to the balance sheet, as you look at your liability for reinsurance, when you're looking at that line item, which is a significant line item on the balance sheet, your claim reserves, for statutory based reporting, that's effectively net of reinsurance. Also, your ceded or your unearned premium liability will also be net of reinsurance. For GAAP, those reserves are grossed up and you would see a separate asset on the books for that reinsurance asset. This slide kind of calls out what those reclasses would be based off specific line items. Again, the ceded loss reserves, loss adjustment expense reserves, ceded unearned premium, and ceded premium payable, all would be grossed up for GAAP reporting presentation. I think what's important to understand there is audited financial statement disclosure that typically calls out what exposure there is to reinsurers. We also generally call that out in a concentration footnote. So I think it's important to know for statutory reporting, you don't really see what credit related risk you have on the balance sheet, again, because that's presented net. So that you should see disclosure in your financials saying X amount of balances have been ceded to external reinsurers. And that not only reflects current balances due from reinsurers on paid claims or paid LAE expenses, but also what reserves you have sitting out there with reinsurers, whether it be on a case basis or through IBNR. Other reclassifications for statutory versus GAAP, real estate owned and occupied by the company. For statutory, that is reflected as an invested asset, which comes into play with some financial ratios. For GAAP, it's just reflected as PP&E. It's not an invested asset. Encumbrances on real estate, it's reflected as a direct reduction of the related asset balance for stat. GAAP shown as a liability, so more examples of a grossed up presentation for GAAP. And then a key one is surplus notes, obviously a generous accounting treatment for statutory, where you can show that as a component of capital and surplus versus GAAP, that would be recognized as a liability on your balance sheet. And then lastly here, I think another key item to understand, because there's a lot of disclosures usually with income taxes, is understanding some of the differences between deferred income taxes. For GAAP, and statutory, there certainly is a level of estimates that are involved. There's judgment involved on what this deferred tax assets can be. For GAAP, effectively the process is evaluating these assets, determining if there needs to be a valuation allowance, and recording that through the income statement. For statutory reporting, there also is a valuation allowance, but there's also a technical admissibility test that's unique to statutory filers, and they actually use potentially a risk-based capital charge, which we'll talk about later, to help determine what the admissibility of that asset can be. Additionally, the presentation of the deferred taxes is different for stat versus GAAP. Again, GAAP, all taxes, current plus deferred, run through one line item on the GAAP basis financial statements through net income. For statutory, your current taxes run through your income statement. However, your deferred taxes run through equity, and they generally net down unrealized gains and losses. So again, differences in reporting when you're comparing the two sets of financial statements. So with that said, we'll move ahead to some of the industry results in the US for 2020. And what we're going to do is start with kind of going over probably the most well-known and most well-cited operating ratios for insurance companies, and that is the loss and LE ratio, the expense ratio, and the combined ratio. I think it'll provide a little bit of backdrop for the next several slides. We have the loss and LAE ratio defined here for you. It's incurred losses plus LAE divided by your earned premium. Your expense ratio would be other underwriting expenses divided by earned premium. The two of those together would total your combined ratio. And effectively what this ratio tells a reader is what is the profit of my company? And it uses a scale of 100%. So any ratio, combined ratio below 100% generally reflects a profit. Anything in excess of 100 would be a deficiency. So in other words, for every dollar of premium I put on the books or I earn, if I have a combined ratio of loss and LAE and expense of 97, I would have $3 of profit. And then likewise, as a component of this, and probably a little bit more prevalent for mutual insurers compared to stock insurers, is policyholder dividend ratios, which reflects return of premium. So if we look at the industry results for 2020, 2020 profitability did outperform 2019. Total US PC industry net underwriting income increased 67.9% year over year, from $3.2 billion in 2019 to $5.4 billion in 2020. Total net income increased 4.4% year over year, from $59.4 billion in 2019 to $62 billion in 2020. And as we have noted here, driving the improved bottom line was about 2.5% growth in net premiums earned, compared to only a 0.7% increase in incurred losses and loss adjustment expenses. Net investment income and realized capital gains totaled $63.3 billion in 2020, compared to $63.1 billion in 2019. So some comparable results there. Overall, the US PC's industry combined ratio did improve slightly by 0.3 points from prior year to 98.6 in 2020 compared to 98.9 in 2019. Interestingly enough, and all these are sourced from AM Best, they estimate that catastrophe losses accounted for an elevated 8 points on the combined ratio in 2020, up from an estimated 4.3 points in 2019. And they kind of defined catastrophe as an industry event costing $25 million or more in insured losses. On a normalized basis, the 2020 US combined ratio was 90.2% in 2020 compared to 94.4% in 2019. So again, improvement all in all in 2020 compared to 2019. There was year-over-year growth in policyholder surplus, about 7.5% growth in 2020 compared to 14.4% growth in surplus in 2019. The biggest difference being while there's both increases in both years in the markets and the investment portfolios, there was substantially more gains recognized in 2019 than in 2020. Obviously, with the consideration of COVID in 2020, to end up where we did at the end of the year, I think everybody was a bit relieved. So, having that increase compared to 2019 being less, I don't know if that's necessarily a bad thing. The other thing that we wanted to call out here, I think it's an interesting slide, is the impact from 2020 COVID-19 inspired premium relief. This was a hotly discussed and debated issue amongst the NEIC and the statutory and the SAPWIG reporting, and how to determine this inspired relief. How should we account for this in financial statements? Obviously, stay-at-home orders and government ordered businesses, closures prompted some P&C insurers to provide this relief. In total, 397 companies returned about $12.9 billion in 2020 associated with these measures. Probably the most prevalent line that we saw returned was the auto lines, but certainly there were other lines that were impacted, including general liabilities, workers' comp, event cancellation, and inland marine. Where stated, 15% seemed to be the most common return of premium, with some as high as 35%. And then again, there was certain options that insurers were effectively allowed to do to record these. Approximately 62% of the relief came in the form of a decline in premium. Some insurers, including Progressive, were allowed to qualify for limited condition exceptions to record premium relief as underwriting expenses rather than a reduction of premium. And then certainly some companies did the premium relief through dividends. I think this is a good example to go through to kind of reflect how an accounting policy can impact ratios for insurance companies. So what this exhibit does is show you, depending on how you did the accounting, what the impact would be on the combined ratio. So in the chart there, before return column would show you, absent any kind of premium relief, we have a combined ratio of 95. If we did the accounting through a reduction of premium, that combined ratio would elevate to 106. And this is all based off of a premise of returning about $135 of premium back to the insured. If we were to account for this as added underwriting expense, the ratio would jump to 110. If we accounted for it as policyholder dividends, the combined ratio would change to 109. Or if we accounted through this as premium balances charged off, there would be no impact on the combined ratio because that line item isn't included in that specific ratio. So certainly having an understanding of what the accounting policies are, how items are reported, those will certainly impact the results of ratios. Some other highlights based off some of these reports. In 2020, the top 10 insurers comprised over 40% of total written premium. In the personal auto space, in 2020, the top 10 auto insurers comprised 74% of total personal auto written premium, compared to 5 years ago. In 2015, the top 10 auto writers captured 65% of the market share. So over the last 5 years, almost a 9% increase in that market share in the personal auto space. Looking at a 5-year income statement for the market, of note, the 2020 underwriting income and net income was the highest in the 5-year period. Looking at net underwriting income in 2020 of $5.4 billion, and net income of almost $62 billion. The 5-year change in surplus over the 5-year period. The industry has averaged a 6.6 after-tax return on capital and surplus. And then also, as noted, the net written premium to policyholder surplus, or leverage ratio, has been between 0.7 times and 0.8 times at each of the respective prior 5 years. Taking a look at the operating ratios over the past 5 years. In 2020, the normalized combined ratio was the lowest in the 5-year period. Looking at that, it's about halfway down to the page. We're at a normalized basis in 2016, 95.3. in 2016 to 2017 of 93, 2018, 92.9, 2019, 94.4, and then 2020, 90.2. Again, some more data analysis of interest. When you're looking at the composition of premium in the P&C industry, the automobile, private passenger, automobile, commercial automobile, auto physical damage continues to be the most substantial composition of the premium at 45% in 2016 and 44% in 2020. So I think we'll transition to some of the key rating agencies, some of the metrics that are cited out there to give you a little bit of background when you hear these items, what people were referring to. So what are insurance company ratings? Why do they matter? They're effectively scores created by a rating agency to succinctly describe what the financial strength of an insurance company is. There's a wide variety of factors that are considered, but I think ultimately what they do is to look at how well the business is doing, how responsibly it's run, and other external factors like vulnerability to catastrophes. Now, each agency has its own methodology. It uses its own rating scale, as you can see. However, I think decisions generally are based off the same criteria and the same data. And ultimately, there's a lot of rating agencies out there. However, as you can see on the slide, the most common ones are these five. So AM Best, Demotech, S&P, Moody's, Fitch. And as noted, and I think probably is most relevant to this audience, would be AM Best and Demotech as insurance-only rating agencies. Also of note, when you're taking a look at ratings, these FSR ratings, not every A+ means the same thing by rating agency. So there could be some different differentiators there depending on what the rating agency utilizes. AM Best, probably the most prevalent rating agency in the insurance area. They perform independent assessments of insurance companies and assign, among other things, financial strength. Insurers' ability to pay claims is of utmost importance, not only to regulators, but also agents and insurers. So therefore, any downgrade in a rating, especially when below B+, can pose significant risk to an insurer. We oftentimes, in discussions with management and committees, we're aware that there's agencies out there that just simply won't do business with insurance companies that may fall below a certain rating, which would significantly impact a company from a distribution perspective. Likewise, as companies seek to expand geographically into new states or expand new products, having this financial strength rating at the strongest it can be is critical. So this is certainly something management pays close attention to. AM Best also has a very well-cited metric called the BCAR, the Best Capital Adequacy Ratio. I didn't provide much information on that in this presentation. I think you could probably spend an entire day just talking about that. But by and large, it utilizes a lot of the criteria that is in your financial statements from a credit risk, asset risk. One of the newer items that they introduced is innovation risk. So that would be another metric that's common out there that would be important to understand as you're governing the entity. Demotech, also a prevalent provider out there, established in 1985, also also produces and issues financial stability ratings for insurance companies. It summarizes their opinion as the insurer's ability to insulate itself from the business cycle. And again, they use A double prime, A prime, exceptional ratings as they go through their analysis. So all these are marketed, known items. Consumers can see them. Obviously, agents can see them. So it's important to have an understanding of what this process is, what management is communicating to the rating agencies, and how information is being interpreted. We'll dive into some of the more common ratios and performance metrics for insurance companies. Again, starting with the combined and operating ratios. I don't know if I could say it enough. This is probably the most widely recognized ratio. An item to call out here on this slide is there is a nuance here between a GAAP combined or operating ratio versus a statutory combined or operating ratio, and that's on the expense side of things. So for GAAP, when you're comparing that ratio, that's done on an earned basis versus statutory is done on a written basis. Another highlight to call out is when you're evaluating your expense ratio, that also includes commissions, your direct commission or your net commission to your agents. So that is included in that line item. So your loss expense plus your dividend gets you down to your combined ratio. And then what we didn't see in the slides before was the investment income ratio, whereby your investment income earned is divided by your premium earned and taken away to get down to your operating ratio. So you have your true operations at the bottom. Another item out there that insurance companies are required to file is the NAIC Insurance Regulatory Information System ratios, or IRIS ratios. It's a system of tests developed by a committee of state insurance departments based on studies of financially troubled entities compared to financially sound entities. Usual ranges are established under each of these tests, and there's 13 for property and casualty. Effectively, the system is intended to assist in identifying entities requiring close surveillance. So this is an annual filing that insurance companies do with the NAIC. It's been in existence for a while, and I think what it does do fairly well, it does give you some kind of benchmark to evaluate some reasonable ranges of ratios. And they're broken down into several categories here: your overall ratios, profitability ratios, liquidity ratios, and reserve ratios. However, just because these are benchmarks and recommended levels, any ratio that does not necessarily fall within the range isn't necessarily a bad thing. For instance, you could take a look at your number 7 there, gross change in policyholder surplus. 50% growth, anything in excess of that might be considered unusual. Well, that might not necessarily be a bad thing if you're growing your surplus by more than that. So I think when regulators and the NAIC, when they take a look at the results of this test, when you start to hit maybe 3 or more ratios that are outside these ranges, that's when they'll come back to companies and start to question what's the story behind why you're outside the range. And then annually, the NAIC does publish the NAIC financial solvency tools, which do explain these ratios in detail. So if you're looking to understand on a more technical basis what the ratios mean, there certainly is some resources out there that give you a pretty good synopsis of how these work. Another resource out there that I wanted to call out, and I think it's a good one. It's relatively new, and it's being issued by NAMIC. I think with the assistance of Aon now. They started doing this in 2018. It's publicly available. but they basically published a report called the Mutual Factor. And it was established in 2018 as a data-driven overview of key performance metrics of the mutual insurance industry in comparison to others in the insurance space, so effectively stock companies. So what I did here was I actually took some excerpts from that report, the most recently published report, which was in 2020, based off 2019 data. So you could kind of see what kind of ratios are out there in the mutual space. So in this chart, looking at the expense ratio for mutual insurance companies, we're at 27.1%, a loss and LE ratio of 72.5%, dividend ratio of 1.5% for a combined of 101.1. Then your net investment income ratio is 6.9%, coming down to an operating ratio of 94.2. Some additional ratios that were published in the report, about halfway down, which I think is an interesting ratio, is taking a look at your ceded to direct written premium ratio, which effectively would be your cost of reinsurance, or how much money you're paying your reinsurers on a calendar year basis. From the mutual industry, you're about 0.09 or almost 10% of premium going to your reinsurers. And as you can see, a little bit further down, capital and surplus growth in 2019 was 11.1%. I also think the report provides some pretty good insight into mutual company performances, including why mutual insurance companies tend to operate with this higher combined ratio. As we go up, right, mutual was at 101.1, stock was at 97.2. Why is that? And I think in part, and it's cited in the report, is pricing strategy can come into play here. For mutuals, rather than, or maybe in addition to dividends, I think mutual insurance companies tend to temper the pace of rate increases, kind of smoothing out the variability and providing a little bit more stable of a pricing mechanism for customers and lower relative premiums compared to stock companies. But because of that, it does potentially lead to higher loss ratios and ultimately combined ratios. Then likewise for dividends, again, that's more prevalent in the mutual space than the stock space, kind of reinforcing the fact that mutual policyholders pretty much are the sole focus of mutual insurers. Additionally, the report gives you a 5-year review of these metrics. Again, the expense ratio about 27.5%, from 27.1% in 2019. I would say an item to think about when you're looking at these types of ratios. We often get asked by committees and management, how are we doing in comparison to other companies? It's a difficult task to do, especially for the smaller to mid-size insurers in the space. Your product mix can certainly dictate what the results of these ratios are. A personal writer versus a commercial writer versus a workers' comp writer versus an all auto writer. These ratios can be very different. Likewise, the seasonality of your business can influence the results of ratios on an interim basis. So when you're comparing, a first quarter or a second quarter for a P&C company compared to the third and fourth quarter, ratios could look completely different just depending on the seasonality of the business. So I would call out that you can kind of take these industry-wide ratios for what they are, but I think ultimately you need to think about your own company's historical performance, where the ratios have been, where they're at, where they're trending, and just have a solid ground and background understanding of why that is. For example, expense ratios. It's not uncommon right now to see those to be significantly elevated from historical levels just because the pure magnitude of IT-related expenses that are running through insurance company financial statements now. I mean, we're seeing for some companies expense ratios that might have been in the upper 20s, low 30s, there might be 10 points added now just because of system upgrades. So having that understanding of why, I think, is of the utmost importance, maybe more so than generally comparing where you're at compared to the industry. We'll touch briefly here on risk-based capital. It's a measure of the minimum capital required for insurer based on formulas considering asset risk, credit risk, underwriting risk, and business risk. It's a solvency tool for regulators. This certainly is an important item against annual filing insurance companies do. Effectively, what it's trying to do is give the regulator a heads up if we have some issues with the company. There's certain levels of surplus that's targeted. And if an insurance company does not meet that target level of surplus, there could be some intervention at the regulatory level. So we've defined some of those levels here as information. You can see what some of the what the target levels are: company action level 200%, regulatory action level 150%, and what those mean. So really, when you're taking a look at the regulatory action level, you're looking basically 1.5 times your required surplus. The insurance commissioner is required to perform an examination or analysis as they deem necessary. So it's a ratio, or it's a filing out there that's used for regulatory purposes. It's cited. We certainly consider that when we're auditing insurance companies. As I mentioned earlier, deferred tax assets could be impacted by the ratio results here. Another resource out there is the insurance expense exhibit, which is required to be filed each year. It effectively allocates expenses and elements of profit or loss to lines of business on both the direct and net basis. It's used to evaluate the profitability of operations by line of business. In addition, the regulators use this data from this filing to develop elements of profitability, both by line of business and by state. And not only that, but they actually potentially use this to evaluate and set premium rates for coverages. So again, kind of going back to a previous thought and comment that, depending on your mix of products, the profitability by line of business can be drastically different. And this exhibit attempts to show and highlight what those differences are. So I think we'll finish up here. I think we only have a couple minutes left, just to highlight some key annual statement schedules and disclosures. As you're aware, or I'm sure you're aware, each insurance company is required to file a regulatory annual statement each year. If I were new to reading a statutory filing, these would probably be the schedules that I would tend to focus on. Obviously, the key financial statements would be your balance sheet, your income statement, your statement of cash flows. But other key areas in that annual statement, which is several hundred pages, there's a schedule called the Underwriting and Investment Expense Exhibit on page 11, which effectively shows how insurance companies are allocating overhead expenses, either through loss adjustment expenses, other underwriting expenses, or investment expenses. And all those flow up through to the income statement and could potentially impact the results of those ratios, operating ratios we were talking about before. So whether or not you categorize something as an investment expense or an underwriting expense could change the results of that ratio. There's also a 5-year historical data page, which shows you the 5-year history of the annual statement results. And it does highlight some of these ratios that we've talked about. It gives you your 5 years worth of combined ratio, your operating ratio. It also gives you 5 years of history of loss development. So how well your losses have been developing 1 year later. All right, so I reserve my losses at the end of 2019. 1 year later, if I'm interested to know how well did I make that estimate for future payments, or if those reserves increased or decreased, that development factor on both the 1 year and a 2 year basis is disclosed in that 5-year historical data. So there's some good information on those historical pages. Schedule Y certainly gives you some information of transactions between related entities. Schedule D is your investment schedule. It gives you pretty much all the information you need to know on your investment portfolio, including what investments you hold, what you bought and sold during the year, what realized gains and losses you recognize, what your investment income was, and it's by detail of security. And likewise, Schedule P would be the claim schedule. It's a 10-year historical schedule showing what your history of claims have been and how they've developed over the past 10 years. Another key schedule would be Schedule T, which gives you not only premiums written by state, also gives you premiums earned, losses paid, unpaid losses, and other expenses, all by state. So if you're a multi-state writer, and it also gives you where you're actively writing business at in, or where you're licensed to write business in. And then lastly, management interrogatories. There's some pages in the statement that kind of give you some insight into what management story of the financial performance was. There's notes, note disclosure, and there's also an MD&A, management discussion analysis that's filed each year. So with that, I think that wraps up what I wanted to go over. Ron, I don't know if there's any questions that came through. I'd be happy to entertain those. But hopefully, I know it's a fairly technical subject. Hopefully that give you kind of a little bit of background of statutory accounting and some of the ratios that are commonly cited.
So Jeff, we didn't receive any technical questions on your presentation. So that's obviously attributed to how well you did and how clear you are, because it was, for the non-financial professional, it was very good. In fact, the one question we did receive through the chat feature was, will your presentation and slide deck be available? And the answer is absolutely. We will make this available to all the attendees and actually other PAMIC members if they want to take a look at it. And you'll be receiving an email sometime after this presentation with the links to the actual video as well as the slide decks. So Jeff, I want to say thank you very much for a great insight into financial ratios and those kinds of things. And I bet with the number of CEOs and other senior executives that are sitting here on this presentation, that this will prove to be very useful, especially in training and or retraining some of their boards and other senior members of their organizations. So thank you, Jeff. With that, we have one last presentation, but we do still want to honor and highlight our remaining sponsors. So we're going to take a 10-minute break at this time so that we can allow the presentation of those sponsors on your screen. So we'll reconvene at about 11:25, and then John Smith and I will start our our presentation, and we should still end it at 12:15. So with that said, Britt, why don't you start the videos?
Running a business is more challenging than it has ever been. We know staying competitive and driving your business goals are your top priority. But the cost of compliance is going up, while internal time and resources are going down, all while the cost of an hourly attorney and consulting fees continue to rise. And with those rising fees, you still have limited accessibility and less than ideal response time. So where do you go for answers so you can quickly get back to achieving your business goals? Enquiron is here to provide you with an on-demand, accessible, and easy-to-use solution that you can begin using immediately. It takes just 1 minute to register. Get unlimited support from our client services team. Save an average of $12,000 annually. Oh, and stay in compliance. Sound too good to be true? Well, it isn't. You get unlimited access. Get started today. And suddenly, the path toward compliance isn't so challenging. In less than 1 minute, you can log in or register and be on your way. Stay focused, stay competitive, and drive your organization's business goals. Let Enquiron help with the rest. Our client services team is standing by to answer any questions you may have. Turn your questions into answers.
What's the best way to protect your business? With Donegal Insurance Group. You've poured your energy, your passion, and your heart into this business, and you want it to succeed for generations to come. That's why our agents partner with you to ensure and protect what you've worked so hard to create. Protect your business. Protect your future. Visit donegalgroup.com/protect to connect with an agent today.
Electrical failure is a big source of fire, personal injury, equipment damage, and lost business. In fact, fires in commercial buildings cause billions of dollars in damages and injure more than 1,000 people each year. What if I gave you the power to look inside your book and detect electrical failure hazards before they cause serious loss? Loss of property, income, even lives. Would you be interested? Of course you would. But how, you ask? While electrical failures cannot be totally eliminated, they can be significantly reduced by applying an electrical risk management strategy, one that leverages engineering knowledge, data, and analytics to help your customers keep electrical equipment and systems operating efficiently and safely. HSB's Electrical Risk Management Program brings technology-driven solutions to pinpoint hotspots so equipment owners can get equipment repaired before it fails. Advanced data and analytics allow us to evaluate conditions and make recommendations to mitigate potential losses. And because we understand each risk has a unique set of conditions and each electrical system has unique characteristics, we apply a consultative, client-centric approach to understanding your customer's operations. Working together, we can design an electrical risk management solution to meet your underwriting and risk assessment needs while helping your customers improve their electrical failure prevention efforts. For more information about electrical risk management, contact your HSB representative.
As an insurer, you understand the importance of fixed income. These investments support the claims-paying ability of your operation. Unfortunately, many investment managers don't take the time to fully understand or communicate just how much is at stake for companies like yours. At Opus, we aim to deliver risk-adjusted results rather than jeopardize your company's financial stability by only seeking the highest total returns. We take the time to understand the role of fixed income within your portfolio. This is one of our key philosophies as an investment manager. This strategy allows us to build a pragmatic approach to risk, a process that plays to the strengths of our investment team while remaining in tune with you, the client. Don't roll the dice. Contact me to learn more about our risk management strategies and schedule a portfolio review. I look forward to hearing from you.
So Brittany, can you see my presentation?
I can. Just make it full screen.
I am. Okay. Well, thank you. Well, we still have a couple of minutes, about 3 or 4 minutes before we said we would start. So, we'll honor that. But I would like to make just 1 or 2 comments before I start this last session. First off, this session you're attending today will go down in history because it is the last one we plan on hosting virtually. And I hope I can hear a lot of clapping going on because our first in-person event is coming up this August with our convention. And if you haven't seen our emails, which would be surprising, please go to our website and take a look at whether or not this program, our convention, fits into your schedule as a registrant, as an exhibitor, or even as a sponsor. And for those people that have already registered or sponsored or exhibited, thank you very, very much for that. And you will be receiving other emails over the course of the next few weeks. So the session that we're ending with is a little different than what we have done in the past. What we wanted to do is take time from the leadership of our companies to take a look at PAMIC and as an organization and what we do for you. So we're going to take a little bit of a dive into PAMIC's development, its past, its present, and its future. And partnering with me on this presentation is somebody that needs no introduction. It's John Smith, President and CEO of Pennsylvania Lumbermen's Mutual Insurance Company. John has invested his whole career in the insurance business, and most of that within the mutual industry. And even more importantly, he has been a leader in PAMIC over the years as chair, as a board member, as chairman of our PAC, and has just been a great individual and financial supporter for PAMIC. He's also a man who has unique skills in motivating people to share their ideas, and in some cases, even their money. He's not going to be asking you for money today. But I do want to mention something that was very powerful. At our last in-person convention in Pittsburgh, we were honoring Ron McKinney, who was the president of Farmers of McCandless, who had just recently passed away of leukemia. And we had chosen the Leukemia and Lymphoma Society as our charity for that event. And with John's help and with the assistance and open pockets of our attendees, we raised well over $25,000 that night, which at that point had been the largest fundraising event for that chapter. And I do thank John for his enthusiasm and effort in doing that. And I believe we're going to see that same kind of effort in today's presentation. So with that said, I do have a slide deck here, and I'm not going to bore you with all of them, but I want to go over kind of the roadmap. The first thing is rules of the road. This presentation is supposed to be interactive. I would like you, if you want to actually turn on your microphones for this and share your thoughts as we talk about things. You could also use the chat function or the Q&A function. And my staff, Laura, Brittany, and Andrea will be our scribes to take down these kinds of things that are going on. As I said, so those are the rules of the road, and I kind of did the introduction already. We have never done this before at PAMIC, where we've actually gone to a live audience and said, hey, what are we doing, and does it make sense for you? Are we doing things well? Are we doing things, should we do things better? Should we do different things? This is your opportunity to share those kinds of things. And the next slide I'm going to show does have a couple of questions I'd like to keep in the back of your mind. And then the rest of the slides I'm going to go through very quickly, because it's just sort of a listing of those programs that we already provide to help jog your memory if that's needed to. And then, of course, the best part of the presentation is John will likely get to adjourn it for the rest of the day. So John, that's probably your most important job today. So with that said, here's kind of the question.
Hold on for a second, Ron. Let me jump in here, if you will.
Sure.
You know, when Ron first asked me to do this, I agreed, but I stipulated that you know, we're looking for frank feedback. We're not looking. This presentation is not looking to resell PAMIC to you. We're looking for you to tell us what's right with PAMIC, and more importantly, tell us what's wrong with PAMIC. What we could do better at PAMIC, areas that perhaps we're not as focused on as we should be focused on. You know, it helps us build a platform for a transition of the organization here over the next couple of years. So please be very frank. I told Ron that you know, he can't be too concerned if someone has a negative comment, and that we can't get all defensive about that. We just need to take that down, and we need to explore that, and you know, help build a plan for the future with that commentary. So please be interactive. Please speak up and speak out, and we'll go from there. So I'll turn it back over to Ron.
Thank you, John. So some of the questions, as John's saying, what we would like you to think about and then comment on is, what do you want and need from PAMIC? What does PAMIC do well? What can PAMIC improve upon? What is PAMIC doing now that is no longer value to you? What new programs or services should PAMIC consider? Everything is on the board. I don't look at this as an opportunity to criticize. I look at this as an opportunity to build. And so, as John mentioned, this, whatever you say is not going to be taken personal, but in a way that means you care about this organization. So the next couple of slides, and I'm not going to read these for you. We've listed out all the things that we've been doing. Some of them we inherited. Most of them, though, are things that were created starting in 2014 when I came on board. So yes, I'm working on my 8th year here at PAMIC, and time has flown. I actually lost all my hair as a result of it, and what I do have is about as gray as John's hair is as well. And networking, we broke it out by our main pillars and our advocacy work, as well as operational things that kind of help you do your jobs more effectively. And then just listing all the different publications that we do. So with that said, I'm going to go back to just the main questions that we put up there and start opening it up for discussions. And if you don't mind, Britt, if you can actually unmute the microphones, and then now give John a chance to sort of solicit comments, and I'd appreciate that. So John, it's all yours.
Thanks, Ron. Why don't you give it the next slide, okay? So, you know, here's what PAMIC has been doing educational wise over the years, and I've attended most of these things at one point in time, as I'm sure many of you have. I would ask you to look at this slide and say to yourself, wow, did I realize that PAMIC was doing all those things? And if not, you know, raise your hand or put something in the chat about it, right? And, you know, is what we've been doing for 80 years or 50 years or 20 years, the right things to be doing going forward. Does it make sense? And think about all the different things that you get involved with different organizations that you're members of, and does this stuff still fit in, or do we need to tweak it or change it or modify it in any way, shape, or form? So I would ask for just positive, negative feedback on this slide. If anybody wants to raise their hand and pass along a thought or two. Don't all speak at once.
Or here's the risk you're going to run. John's going to pick one of you folks out and say, hey, why don't you give us a comment? So if you don't want him to do that, I advise you to speak up. Otherwise, this is going to be a pretty quick session.
Yep. So everyone would vote to continue to do all these topics just the way we're doing them now. Is that right?
Hey, John, this is Jonah. I think I'm unmuted. Is that fair to say?
Yes, you are, Jonah.
I would just say that a lot of what PAMIC has been doing really supports what I consider to be, to be the three pillars that I personally expect to get out of an association like PAMIC, and that runs along education, it's networking, and it's the advocacy pieces. And I think the organization has done that really well. I think the bar continues to be raised every year, as I see it, for the past 5 or 6 years. I'm not saying more can't be done, but when I think about those three pieces of PAMIC, I know I'm getting the value that I expect. Okay, maybe the networking not so much in the past year, but I don't think that's PAMIC's fault.
No, I agree. Okay.
If I had to think about things where, we could improve or do more, I think it's thinking about some of the things where the smaller mutuals are having challenges. That's in things like technology, making sure, our compliance is in place. And I know I've had this conversation with a few others. I won't, name any names, but how can we work together in certain ways that is not outside of what we're allowed to do, but whether it's affiliations or not, but assisting each other in, working together with, is it things like technology? Is it making sure we're in, data compliance? And that's where I think we could go next, is knowing the challenges that the mutual space is going to have, or is having and will have. Can we take that to one more level? And I'm not sure if that's the PAMIC level, or if it's the NAMIC level, or a combination of the two. But man, PAMIC has moved really more from just the Pennsylvania Association to it seems to be really the Mid-Atlantic region, in my mind.
Are you thinking about some kind of shared service organization? Is that what you're, where a group of companies come together and they share a service, whether it's compliance or processing, or I don't know what it would be, human resources, whatever the case may be, right? Where instead of each company having its own, and I'm not talking about affiliations or acquisitions or anything along those lines, but some kind of shared service organization
that's what I'm thinking. Yeah.
Yeah, that maybe is made up of a subset of members of those organizations, boards, and sort of is underneath the PAMIC umbrella somehow. Interesting concept. And where it's not, where you're not giving up control of the entity or something along those lines. It's interesting.
That is a great idea, a very interesting idea. And actually, the board did speak a little bit about this yesterday, didn't come to any conclusions, but what role should PAMIC play in this kind of situation? So very timely, Joan. I appreciate that.
If I was thinking about that a little bit further, right, I've seen other organizations, I've seen an organization try to pull that together and then embrace smaller mutuals. And it always felt to me like there was a takeover type of thing behind the scenes someplace, as opposed to, 3 or 4 or 5 smaller mutuals coming together and saying, hey, let's explore this as a group, but without, that part of it, that takeover or that affiliation being part of it. And that's interesting. Yeah, good thought. Maybe the next slide, Ron, right?
All right. Well, I did go to the networking slide.
Okay.
Yeah.
So these were talking about the different value of PAMIC, right? These are different things that PAMIC has done and gives you as an opportunity. We, for instance, use the committee memberships a lot. We'd like to put our younger people that are on an upward move into the committees, and so we're very positive about that. We don't do very well authoring in PAMIC Pulse, but we're going to try to do better there. But so are there things here that you guys look at and say, I use that term unisex, by the way, we should try to add this, or this is really not working from a value proposition? Anyone?
Okay.
All right.
Well, here's the other thing. You can share, if you're a little shy and don't want to be, you don't want your voice heard, you can always email me or even John and let us know what's on your mind. I think if we were in in front of each other, this is a lot easier conversation to have.
Well, and I would suggest, Ron, that if they've got something good to say about PAMIC, they go ahead and say that to you. If they got something they'd rather not come to you anonymously, then they should reach out to me, because I'll be happy to bend that information along to you. So give me the next slide here. Lobbying regulatory. This is the third leg of the stool. Congressional contact program, online legislative tracking, state-by-state compliance listing. Feedback here from anyone?
I'm not sure if this is exactly in relation to this slide, but Frank, you did have your hand raised. Did you have a comment to add?
Okay. Either he's talking wildly and he's muted, or he doesn't have a phone. I've seen that happen.
Okay.
All right. Give me the next one.
Okay.
Again, all benefits of PAMIC. Anything wrong here? Anything right? Anybody? Is there anybody looking at this saying, I didn't know that PAMIC did that? I, for instance, didn't know there was a PAMIC cybersecurity center. I probably should have known that because I've read the slides once already. Frank, you have your hand up.
Yeah, John, can you hear me now?
Yep, can hear you now.
Yeah, I just want to touch on the earlier we talked about doing things jointly. And I just want to comment that in the technology space, I think there's a lot of opportunity to do that. I spent 20 years in banking before I got into the insurance side. And in that side, there was a lot of collaboration on the banks to do things to be able to get economies of scale. And I think there's a lot of opportunity with the smaller insurance players to do exactly the same thing. And I think as we work this year with Andrea on the technology seminars and things like that, I would really be anxious to hear what people would like to see as things that they might be able to work with others through PAMIC to get those economy scales to help them do things in a more cost-effective way. So anybody who's got any ideas or things like that, certainly would love to hear about them, and maybe we can get them onto the technology seminar roadmap.
Well, it's interesting because as I'm thinking about this cybersecurity, right, and we're nuts about this topic. Of course, we're a bit bigger than many of the PAMIC companies, but we're doing at least a webinar or a cyber mailing seminar or requirement to each one of our employees every month, right? And it might involve a 7 or 8 or 10-minute video and 3 or 4 or 5 questions, and it could be on any cybersecurity topic, phishing or ransomware, whatever the case may be. But it's required, and I sit there and I think to myself, it's not PLM content that we're using. We're using, cybersecurity content, and we have time to do that because we're a bigger company. Penn National has time to do that because they've got people devoted to it. But the smaller PAMIC members, it's probably a rougher thing for them to do, right? So if there was a training plan or a training program where, you just roll that down to the members and you let them adopt it and move forward. It's already being done by the bigger companies in the organization. So I just throw that out as a thought.
John, that's actually a very timely thought, because the insurance department has made me aware that they're looking to adopt the Cybersecurity Model Act at the NAIC. That's not necessarily a bad thing, but historically they haven't had an interest in doing that. Now I think because of the the national exposure for a lot of these big hacks that have gone on, they're taking it more seriously. So, because of that issue, this becomes much more timely as well. And I think your point about resources is even more on point, that a smaller company, is where the one person is chief cook and bottle washer. It's hard to also, think about these other strategic issues that are out there. So
Right.
PAMIC can fill that role. So that's something that I take to heart. So.
Well, and I think it's something that, why would a small company who's got, 6 people in it or whatever the case may be, need to take the time and energy to recreate the wheel that somebody, who has already done it. So we somehow get that underneath the PAMIC umbrella and make it available to them all. That just, and cyber seems to be different than human resources or law, where that might be a little more difficult to do, right? But, and I guess I think about it, Ron, and I've always said this, that, larger companies, I think, have a larger obligation to the organization and to its members than smaller companies to lead the way on that type of stuff. So I think the bottom one on this page, career portal, that to me is another interesting area. We do a huge, not a huge, but we do a high school internship program plus a college internship program here, and it's not as big as many companies, but we'll have 5 college students and 4 high school students in here, and our goal is to turn them into insurance people, risk management people, and I think I know there's Carla Corrado in our office works with you guys on some stuff, and that just seems to be an area where there could be a lot more work done. I think of a guy like Mike Yeager, who went in as the busboy at Lehigh Mutual or Community Insurance, and never left and ended up running a company now. Whether you're a Mike Yeager fan or whatever, not really it's not the issue. It's the issue of we don't see enough of those people anymore that want to come in, and I think the smaller companies are struggling a little bit to get the leadership they need. So, anybody have any thoughts on that? All right. I think we have one more, Ron.
No, that was the last. Well, hold on.
Yeah.
No, but publications.
Yeah.
Yeah, that was it. Just putting out there what we provide to folks.
Anybody have any feedback on this? The biggest problem I have is signing into these things. I seem to get lost in the mix there a lot, but that's not just PAMIC. That's because I'm an old gray-haired guy, right? So I can't get into NAMIC half of the time either, right? So that's just me. But anybody else have anything here? Okay. All right. Well, from my standpoint, I appreciate the feedback. Tough to do on a call like this, but it's an attempt, and we'll continue to work on it to develop more feedback. And I would really, truly invite, if you got something nice to say about PAMIC, send it to Ron. If you got something that you really don't want to stick your head up out of the hole, send it to me, and I'll be happy to, clean it up, eliminate your name and identification and pass it along to PAMIC accordingly. So we'll have an anonymous approach there. All right.
And John, just to follow up on your closing comments, there is, 3 things came out of this last 15 or 20-minute discussion, and it came from the audience. And I do appreciate these things. And we will take a hard look at them and what we can do, what we should do. And I will share this with the board as well, so that they understand, what their membership is, the folks that are overseeing me understand what the membership wants. So I do appreciate everything. And I know you folks are not shy. So when you see me in the hallway or any of our leaders in the hallway, feel free to share your comments with them as well. Because, I'm not shy of criticism. I want to make this a great organization, or a greater organization than it already is. And so do the leaders of PAMIC. So with that, John, I want to say thank you for taking time out of your schedule. John's been a traveling fool lately. And so I think it was a huge effort to get him in the office this time. To do this. So I thank you, John. And with that, I'll just let you close with any last comments, and then Brittany will end the session. And Andrea, if you have any final comments as well on logistics, please chime in.
I have nothing, but Ron's right. I've been out in the last 5 weeks. I've been out each week flying and visiting customers all over the country. And Philadelphia is opening up tomorrow. I understand fully, and that's a blessing, and we're looking forward to getting back to some normalcy, if you will. So I hope you and your team have done a good job in getting yourselves to where you are today. So
great.
Thanks.
Andrea, anything to offer?
No, I don't think so. I think you mentioned a couple times that the convention is on and registrations are open. So that's all I would have to say. Everybody go take a look at the website.
Okay, great. Thank you. And for those people that participated in today's session, I thank you very much for taking time out of your schedule. We're going to continue to offer these typical type of seminars, maybe new ones. And last year was a watershed year for PAMIC. Over 50 different free webinars on topics of interest were hosted, one to keep people engaged with PAMIC. And I think we've learned a lot on how valuable those things are, and we'll continue to offer them. So with that, I want to say thank you very much. You will be receiving an opportunity to comment and on the presentation sometime later this week. But with that, I want to say thank you for attending. Have a great weekend, and with summer beginning very soon, have a great, safe summer. So thank you very much.
Thank you.